which is Little Traverse Bay Band of Odawa Indians versus the MPSC. Each side, let me just see where's my deal here. 20 minutes of argument per side. You've made arrangements to divide your time, I think both sides. And I understand we have a lot of people here. We're going to feel free to introduce who's with you at council table, and then we'll start your time running from there. As always, there's a 2-minute fire-free zone that you are able to waive if you would like, and you can reserve time for rebuttal. We just ask that you try and keep track of it yourself. So go ahead and proceed when you're ready.
Very good. Thank you, Chief Justice Kavanaugh. David Scott with the Environmental Law and Policy Center. I'm representing ELPC and the Michigan Climate Action Network. With me at council table is Adam Rachensky of Earth Justice, who will be arguing the second issue. I'll be arguing the first. Also at council table is Tom Samar and Debbie Chisowar from Earth Justice as well, Doug Shapiro, former judge, and Chad Hughes from ELPC as well. So,
thank you.
Thank you.
Go ahead and proceed.
May it please the court. We'll reserve 4 minutes for rebuttal. I'll stick to 8 minutes, so my co-counsel has 8 minutes as well. We'll do our best to stay within those times, subject to the court's questions, of course. This case involves applying the Michigan Environmental Protection Act to a massive project to build a 4-mile tunnel under the Straits of Mackinac for an oil pipeline. The Court of Appeals erred by approving the Commission's lopsided MEPA analysis and by deferring to its conclusions. This court should reverse both errors and remand this case back to the Commission. MEPA fulfills a constitutional mandate to protect Michigan's environment from pollution. The statute does that by making courts, not agencies, the ultimate decision maker on issues of environmental protection. This court held in WEMEAC that it is reversible error for a court to defer to an agency's conclusions under MEPA, rather than exercising independent judgment. That rule answers the first question on appeal here. Reviewing courts must make independent judgments, not defer to agencies. Judicial review of an agency happens under MEPA in 2 ways. First, when there's a lawsuit and the court directs the parties to an agency under Section 1704. Second, when a court reviews an agency proceeding under Section 1705. In both scenarios, the legislature directed courts to make their own independent environmental judgments. Section 1704 says courts must determine whether adequate protection from pollution, impairment, or destruction is afforded and adjudicate the impact of the conduct on the air, water, or natural resources. Similarly, Section 1705 says that in any judicial review, pollution, impairment, or destruction of the air, water, or natural resources shall be determined by courts. When a statute uses similar words in separate provisions, we interpret them consistently. And that's exactly what this court did in WEMEAC. The court interpreted the similar language of Section 1704 and 1705 together as a whole and found it requires independent judgments by courts and prohibits deference to agencies. That rule should apply to judicial review regardless of whether a MEPA claim begins in a lawsuit or an administrative proceeding. Courts must make independent judgments under 1705 just as they must under 1704. Enbridge agreed with that proposition in the briefing before the Court of Appeals. They cited WEMEAC, and they told the Court of Appeals that it reviews de novo the Commission's determinations under MEPA. They've changed their position before this court. Now they argue that WEMEAC is somehow limited. They argue it only applies to judicial review under Section 1704, but not under Section 1705. There is no basis for limiting WEMEAC's holding in that way. Appellee's position is contrary to MEPA's text, history, and purpose.
Counsel, I just wanted you to give you a chance to respond to opposing counsel's view that this would somehow be an impossibility, that appellate courts aren't in the position of looking at agency decisions and fact-finding and doing a de novo review. And I just wanted to get your view on that. I think you've outlined it in the brief, but I was wondering if you could articulate that for us.
Thank you, Justice Welch. Our position doesn't require courts to be fact-finders. When they're reviewing an agency decision under Section 1705, they receive an administrative record, and that's what's reviewed. That was part of the record in WEMEAC. So The decisions that Section 1705 requires of courts is to apply MIPA's legal standard to a factual record. Determining whether environmental harm rises to the level of impairment or destruction, that's one decision that has to be made. Another decision has to be made is whether feasible and prudent alternatives do or do not exist, and also whether conduct is or is not consistent with the promotion of public health, safety, and welfare. Those were the decisions that are articulated in WEMIAC and in the Ray case that courts have to make, applying the legal standards of the statute to a factual record. And so in WEMIAC, this court was not a fact finder. It reviewed the record de novo and reached its own decisions as required by Section 1705. So nothing about our position would require changing the courtroom to allow testimony here, requiring courts of appeals to receive evidence. It's not a fact-finding decision. It's applying legal standards to a factual record, which courts do all the time.
So if we were to agree with your premise, and I guess the premise that's in the next case, that there was something missing in the analysis, would the proper way to handle that be to send it back to the commission to get the additional evidence that you argue was kept out of the case, do a new review, and then I assume it would come back de novo potentially if it were to come to us, or the Court of Appeals?
So Justice Welch, unlike WEMIAC where the record was complete, here we do have this second issue on appeal where we were precluded from developing evidence, presenting evidence, and Mr. Rachensky will address that, but there are important gaps in the record here. And so yes, the remedy here is to send it back to the commission to allow development of the gaps that were prohibited before, and then the commission will make a MIPA decision, and that will be subject to review in the Court of Appeals, and the application of MIPA's legal standards to that factual record, the Court of Appeals needs to do independently, de novo, as WEMIAC holds, and then potentially a further appeal if one of the parties brings it here. But that's how it would work.
So is that only required if we agree with the second issue about the scope of the evidence that was either included or precluded? Because I think the opposing side is saying, look, even if we do look at de novo review, you have enough here to sustain the Court of Appeals decision and the MPSC's decision.
I think the argument that they're making there is there's a false premise there, in that I think their argument there is based on the idea that the commission considered alternatives. But the part of our second issue that's really important is that the alternatives analysis that the commission did was fundamentally flawed. It was completely lopsided. They considered only the environmental harms within the footprint of the tunnel and compared that to environmental harms on different routes. So that was a lopsided analysis that needs to be corrected. So it's not the case that there is a basis right now on this record for the court to affirm the commission's decision. It needs to go back.
So even if we agreed with you, like, the alternatives analysis was lopsided, we know this record is massive, and there were a lot of hearings and a lot of findings. And so it's your view that there's not enough right now, even if we were to agree, they have to relook at the alternatives. You would say there's more evidence needed to put in the record to properly analyze that.
Well, Justice Welch, I would submit that the bulk of the record is focused on the Act 16 issues because at the outset of the case, we were prevented from developing these types of issues that would be considered under MIPA. So the Act 16 pieces are what they are, but what is missing is the MIPA analysis, a full record for MIPA analysis, and then an independent review and judgment under MIPA. So that's what needs to be done, and there was very little. I mean, if you look at the final order of the commission, only the last, I venture to guess, 5% of the pages are devoted to MIPA. The bulk of it is Act 16.
Counselor, one more question on the standard of review. The MPSC suggests that maybe there would be different standards for the impairment, which could be de novo, versus a deferential review of the alternatives. Can you, I know your time, you quickly react to that.
Thank you, Justice Thomas. There's no textual basis for a different standard for the alternatives analysis and the impairment determination. The statute makes those decisions courts must make. They're mandatory decisions that courts must make under 1705 regardless. And it makes no sense, and it's atextual to say that a deferential standard would apply. As this court said in Ray, whether feasible and prudent alternatives do or do not exist, that is a conclusion that a court needs to draw, applying the legal standard to the factual record, and that's Ray at page 312 and 313, just as the determination of impairments must be made independently. So there should not be a different standard. If there are no further questions, I'll hand it off to my co-counsel. Thank you.
Adam Rachensky on behalf of the Bay Mills Indian Community, Grand Traverse Band of Ottawa and Chippewa Indians, the Little Traverse Bay Band of Odawa Indians, and the Nottawasepi Huron Band of the Potawatomi. The proposed Line 5 tunnel project threatens natural, cultural, and economic resources that are vitally important to these tribal nations. They join this proceeding to protect those resources, alleging that the proposed project is likely to have the effect of polluting, impairing, and destroying natural resources by prolonging and increasing the risk of oil spill for decades. MEPA requires that administrative agencies determine whether alleged environmental effects are likely, and the Commission didn't do that. Decisions of the Court of Appeals and the Commission must be reversed as they failed to follow MEPA's requirements in at least two ways. First, in a legal ruling at the outset of this proceeding, the Commission incorrectly interpreted MEPA and held that only a subset of the project's alleged likely effects would be determined, and that certain categories of effects would be excluded from consideration entirely. The Court of Appeals upheld the Commission's interpretation, while similarly failing to recognize that conduct under review can have effects that go beyond the immediate footprint of construction. And second, the Commission's incorrect limitation on the scope of its determinations led to an imbalanced assessment of environmental risk.
Counsel, I want to jump in just because our time is precious here.
Yeah.
So I want to just ask about that argument. So in the other side's briefs, they argue that your view would mean anytime a portion of a pipeline needs to be sort of repaired or replaced or maybe even swapped out because it's damaged, that it would require a full review of the whole pipeline. And that would disincentivize companies from coming forward to make repairs. And I'm wondering what your response is to that. Is this different? Are they correct? Is that the way it's supposed to be? What's your response to that?
Thanks, Justice Welch. My response to that argument put forth by appellees and adverse amici is that it's overblown and it's a bit of a slippery slope argument. First, because the Commission already held in its June 2020 order that this case is not maintenance. In that order, they recognized that repairing a pipeline or even rebuilding a segment of a pipeline to mirror the original is maintenance that does not require an application under Act 16. So this court's decision in this case, although it's a high court and its interpretation of MEPA would matter for everything, is not directly applicable to a maintenance case because this Commission already held that this case is not maintenance. So it's fundamentally different. In that sense.
So anytime you take a detour from something that's existing, does that make it essentially a new project where we can look at everything?
It depends. So MEPA prescribes that an administrative agency must look at alleged likely effects. I think there are some circumstances in which if you're replacing a random segment of a pipeline through a cornfield and taking a slightly different route, that may not bring in or prolong and extend the environmental effects of a pipeline in the same way that this remarkably unique and unprecedented project does, where both the underlying segment to replace is the linchpin of the entire system, as the Commission recognized in its April 2021 order, but also where it's very old, it's fundamentally different from the other segments of this pipeline in that it crosses the Straits of Mackinac, and as the Attorney General notes in her amicus brief, the underlying segment to be replaced here is subject to lots of legal doubt in terms of its legal authority to operate, including having its easement revoked and being subject to a second suit by the Attorney General seeking to shut it down. So in that sense, I think it's fundamentally different from maintenance because the Commission already held such in this case, but also just the circumstances surrounding this pipeline make it so that they may be in play here. And I can imagine scenarios where they may not be in play for a linear infrastructure project where something's being moved or repaired.
It does seem like a hard line to draw. If we're trying to figure out what is it and where do we draw the line, ideally, it needs to be some sort of a test that's applicable. We heard from utilities, this could be really a problem for every electrical upgrade, and so obviously our decision can impact many other segments of the utility infrastructure.
It could, and I think for those reasons that the commission already recognized, that this case is not maintenance, that differentiates it a bit. I think it's important to recognize as well, Justice Welch, that we're not asking this court to determine that those are likely effects under MEPA. We're asking this court to determine a rule that the commission must make a determination as to whether they are likely polluting, impairing, or destroying effects under MEPA, which requires record evidence and appears in the plain text of MCL 324.17052. That's like the burden on the agency to decide. So this court need not agree with us even that those prolonged and increased risk of oil spills are the likely effects of this project, but rather that the commission must determine whether they or not they are. And I think that may assist in some of the line drawing and
Thank you.
Provide some guardrails. Thanks. The effects of the conduct can, and depending on the nature and scope of the project at issue, often do go beyond the scope of the immediate footprint of that conduct. The Court of Appeals in its decision did not grapple with the word alleged in 17052 or the phrase has or is likely to have such an effect. The court merely reasoned that the commission, by looking only at the desired conduct, was following the plain language of the statute, and it couldn't go beyond that. And doing so, citing the United Parcel Service case, would be reading something into MEPA that does not appear in the plain text. But appellants never asked the Court of Appeals to read anything into the statute. We asked the Court of Appeals to give effect to the phrase has or is likely to have such an effect, which appears in the plain text of 17052. The court didn't grapple with that, and whether those alleged effects are likely is a legal determination that requires fact-specific inquiries determined on a case-by-case basis based on the evidence presented, not something to be excluded at the outset of a proceeding on a motion in limine, which really wasn't excluding any particular piece of evidence, but functioned as a pre-discovery motion for summary disposition, essentially, that dismissed our MEPA claim for failure to state a claim. But it was reviewed not under that standard, and instead it was reviewed essentially accepting Enbridge's allegations as true, while ours as not true, and prevented the development of this evidence and us being able to develop that claim altogether.
I would just note that you have 3 minutes and 40 seconds left if you wanted to reserve any time.
Thank you, Chief Justice Kavanaugh. I will take that offer and we'll reserve the rest of our time for rebuttal.
Thank you.
Good morning, Your Honors. John Bursch on behalf of Enbridge. At table with me are co-counsel Mike Ashton, counsel for the MPSC, Dan Sonneveld and Amit Singh, counsel for the Michigan Propane Gas Association and National Propane Gas Association, Ashley Chrysler, and co-counsel Sean Gallagher. In this case, the first case, I'll be presenting and answering questions until they're exhausted, and if there happen to be 2 minutes or so left, then Mr. Sonneveld will take the remainder of that time. Okay. In the next case, the public trust case, Mr. Sonneveld will start and take the first 5 minutes and then cede the remaining 15 minutes to me.
Okay.
May it please the court. Last December, a federal court held that the federal government alone can shut down an international pipeline. And so the alternatives here are stark. Will Line 5 continue operating on the lakebed, or will it be moved to a protective tunnel? Now, the environmental calculus there is obvious, and so is the legal. In this case, traditional standards of review apply to MEPA 1705 proceedings, and under any standard, this safety and environmental upgrade is more protective of the environment than the status quo or any alternative. In the next case, the PSC lacks statutory authority to consider common law theories like public trust, and in any event, the protective tunnel is more protective of the public trust than the status quo. So this court should reject appellant's attempt to hinder a safer pipeline and instead allow the tunnel project to move forward expeditiously. Now, I want to start where my friend Mr. Scott did, because he started in the wrong place. He immediately honed in on 1705 sub 2 and the shall be determined language, and somehow said that the PSC and the Court of Appeals did not determine that there would be an environmental impairment here. They did. They concluded that there would be an impairment. The Court of Appeals affirmed that, and we don't contest that. What this case is about is the language in 1705 sub 2 after the if, because even conduct that impairs, whether it's MIPA or the public trust, can be authorized if there is no feasible and prudent alternative. And what's different about this case is that the status quo is a pipeline. In an ordinary case, if we were coming to build a fresh pipeline, as you're considering alternatives, one alternative might be don't build the pipeline. But here, if you do nothing, the pipeline continues to operate across the straits. And so it's pretty easy then to determine that this is not a MIPA problem. Consider some of the alternatives. If you put product on rail and on boats and on cars, not only do you have more greenhouse gases and greater risk of release, as the PSC found, but the pipeline will still be operating on the lake bed. By any measure, that's demonstrably worse. What if you throw rocks over the pipe so that you can eliminate the 0.001 chance, that's 1/1000% chance, that an anchor strike might hit line 5? Well, that eliminates your ability to visually inspect and easily do repairs on line 5 in the straits. So this isn't an apples and oranges comparison, because the status quo is an operating pipeline on the straits. It's not a should we build it or not, and that really drives all of this analysis. And so,
is there a final determination on that point yet? I
On
mean,
which
they're both the issue of the revocation of the easement and the Attorney General's suit are under appellate review, right?
they are under appellate review, but the PSC and reviewing courts take the facts as they find them. And here, that's a pipeline which a federal district court has said can operate indefinitely. And just to assure the court that this isn't a matter of an aging pipeline, when you're talking about a seamless pipeline going across the straits, it's not like the bones in your body that can get brittle. As long as it's properly maintained, and it has been, it can literally last indefinitely. That pipeline has the same integrity today as when it was approved back in 1953. And it's also the most heavily regulated pipeline in the United States by the federal regulators, which the federal court, Judge Yonker said, are the exclusive regulatory authorities to decide whether the pipeline keeps operating. So the question here isn't, does Line 5 operate or not? The question is, does the pipeline operate on the straits lake bed or in the tunnel? And again, that's an easy MIPA analysis. Now, I'm happy to walk the court through the statutory reasons why we think that your judicial review here is traditional deference and not de novo. But it doesn't make any difference, because even under a de novo review, there is no scenario that gets the pipes out of the water. And everyone, including the other side of this case, agrees that the pipes and the Great Lakes ecosystem are better off if they're in the protective tunnel. So this whole thing is a bit of a nothing burger when it comes to the MIPA analysis.
Can I ask you, saying the inquiry about whether or not there are likely effects, and you said that's already been determined, you know, like that box has been checked and we're going on. Doesn't the nature of the effect have relevance? I mean, you could have, I mean, whether it's affecting, you know, a single fish or an entire, you know, population of fish. I mean, it makes a difference, right? Of not only the scope and breadth of the effect, but also then it impacts what the alternatives are. So just finding that the commission found, yeah, there's you know, there's likely to be environmental effect, so we're just going to go to alternatives. It does, I mean, it's relevant, their point of whether or not there was sufficient evidence of the scope and breadth of what the commission found was the environmental effect.
Sure, Chief Justice Kavanaugh, and the commission did exactly what it was supposed to do, which was analyze the conduct at issue. Because if the status quo, they do absolutely nothing, means the continued operation of the pipeline on the straits bed, then all these collateral things that they talk about, whether there could be oil spills on other parts of the line and greenhouse gas effects, those are already baked into the status quo. None of that will change. The MPSC found that the construction, which is what's at issue here, would impair the environment and the public trust in like 10 different ways. You know, there's going to be air pollution from doing the construction. There's going to be rock that's upset. There's going to be dirt that's hauled away. All of those things have an impact on the natural environment and on the public trust. But they are so de minimis compared to the risk, the risk that they point to, that the governor points to, the AG points to, and that we acknowledge, a 0.001 risk of an anchor strike in the Great Lakes that would cause a deprivation to the ecosystem. So the MPSC, they went into all kinds of detail about this, but ultimately, this is the finding that we think you should defer to, or if you want, review it de novo, you would reach the same conclusion. This is page 305 of the PSC opinion. The commission finds, this is a fact finding, that the replacement project essentially eliminates the risk of adverse impacts that may result from a potential release from Line 5 at the Straits and protects unique ecological and natural resources that are of vital significance to the state and its residents, to tribal governments and their members, to public water supplies, and to the regional economy. I mean, that's the whole ball of wax right there. We think you should defer to that fact finding. If you want to review it de novo, you can reach the same conclusion here. But what they're asking for is for this to go back, for thousands of pages of additional evidence to be reintroduced, for the PSC to make another decision, and then be appealed all the way back up to this court. We're talking about a 5 or 6 year delay. And every single day of that 5 to 6 years, the pipeline is going to be continuing to operate on the lake bed of the Straits. And no one wants that. I mean, it's really bizarre that they're asking for that kind of relief. You know, ironically, it's the pipeline company that has the most pro-environment position here because we want to do everything we can to eliminate that 0.001 anchor strike risk, and they want to do everything that they can to perpetuate it. It doesn't even make sense.
Counsel, does it matter, I think the Attorney General maybe pointed this out, that like an analysis that we would sort of do today, of course, did not happen in 1953. And so, I mean, I guess that ship sailed, but is there ever a moment we can look at the big project? I'm guessing your answer is no, but tell me why.
Well, in theory, they could have brought an APA action under Section 91. They could have brought a common law public trust theory, similar to what the Attorney General did. And what the federal court has now said, I think definitively, I argued that case, I've read the opinion, I'm happy to discuss the details of that. But only the federal government gets to decide if the pipeline as it's operating is unsafe. And there's a reason for that. When you've got a pipeline that's providing energy to millions of people in Michigan, Ohio, and in Canada, the United States and the Canadian government have a strong interest in making sure that pipeline keeps operating. So in order for them to prevail and even have a chance at shutting down the pipeline, they would first have to convince the Sixth Circuit or the Supreme Court that the Pipeline Safety Act doesn't preempt all this, and it clearly does. And second, that under the federal common law of foreign affairs, that the 1977 treaty between the US and Canada, which prohibits any local officials, state or local, judicial or executive, from shutting down the pipeline, only the countries get to do that, take all of this out of the hands of the Attorney General, the Governor, and anyone else who wants to have a say in this. Now, all that said, I want to assure you, Justice Welch, again, this is the most heavily regulated pipeline in the United States. PHMSA, the Pipeline Regulatory Agency, is all over this. If there were any issues, they would shut it down in a heartbeat because no one wants to keep the Great Lakes ecosystem free of any impairments more than the federal government and frankly, Enbridge itself. We don't want to have an accident there. And so that's why we want to put it in the protective tunnel. The previous governor agreed that that was the best option. The courts have consistently approved that. And now the only thing standing in the way are this court's approval of the PSC permit, the Army Corps of Engineers permit, which is pending and should be issued relatively soon, and the Eagle permit, which is in the same boat. You know, it's on the verge of being granted, we hope.
So if the Eagle permit is denied, does that tank the whole project?
It would tank the whole project, and then the status quo would continue. We expect that to be granted. And I don't want to get too much ahead of myself and get into the second case, but I think that Flo is right when they say at page, I believe it's 26, yes, of their reply brief, that Eagle is the one that's considering all of the public trust aspects of this case. Trust Eagle to do this. There may be another opportunity when that case gets appealed if you want to talk about public trust things. But I don't want to get too much into that case. You know, I'll save that for the next argument. The only point that I want to make here is that the pipeline's going to continue to operate. There's nothing that this proceeding, the PSC, or these plaintiffs can do to stop that from happening. And so then when you're looking at the alternatives, the environmental and the legal alternatives, again, it's stark. Where do you want the pipeline? Do you want it in the tunnel, or do you want it operating in the water? We should all want it operating in the tunnel.
So even if I agree with you on that point, we still have this alternatives and this sort of apples to oranges argument that Brother Counsel has made. Why was it correct to only look at the tunnel and its immediate effects versus the railroad line across all of, the streams and ponds.
Yes, Justice Welch. And this goes back to my opening point, that what we're talking about here is a status quo, which is a pipeline in the water. If you were coming and approaching this case where the pipeline was being authorized and built for the very first time, so say 1953 did never happen, and so now we're talking about that, it would have been error for the PSC to not evaluate the impact of the entire pipeline on the natural environment and on the public trust. Of course that makes sense. But here you're talking about the status quo. If you turn down this permit application and they're not able to go forward with the project, then Line 5 continues to run on the Straits Lake bed and nothing changes. So when you're comparing alternatives, you have to compare an operating pipeline, which has already been approved, and then this modest change, moving it into the tunnel, versus alternatives that would move that product somewhere else. And the PSC more than adequately concluded that rail, cars, and ships, putting all this product on those is really not only not feasible, but it's certainly not prudent because it increases exponentially the likelihood of risk, as well as tremendous increase in greenhouse gases. Really, our position is that the PSC, if anything, went too far. Like by taking evidence on the greenhouse gases, which they asked for and the PSC granted, that's not even at issue here because the status quo, do nothing, you have the same greenhouse gases today, tomorrow, 10 years from now, 50 years from now. None of that changes. With respect to the risk of oil spill, that's the same today, tomorrow, 10 years from now, 50 years from now. So it's not an apples and oranges comparison. It's you've got an operating pipeline already. What are these other alternatives if we do them in addition to an operating pipeline? It's like apples plus oranges.
So, Counselor, you're sort of defining the scope of what the feasible and prudent alternatives are based on what the existing project is. But, us just looking at how we define that for purposes of NEPA law, like how would you have us define feasible and prudent alternatives? How are they fluid enough to vary, as you're asking us, with what the pre-existing project is? What do we look to there?
Well, feasible and prudent, I think, have a capacious meaning, and I don't think that Michigan agencies or, frankly, the legislature or other portions of the executive branch have had difficulty applying those in the past. Feasible just means, is it doable? So, for example, one of the proposals here as an alternative was a direct drill, and at the time that this was all being permitted, they all agreed that that was not feasible. This would have been the longest directional drill project in the history of the world, and they didn't think that was possible. As far as prudent, that's where you start to go into these things like, does it make sense to have the existing pipeline keep operating on the straits and to have some alternative mechanism where you do product somewhere else? Under a 10-year-old's analysis, you could see that it's better just have one pipeline than pipeline plus boat, rail, and car and things like that. So those don't really come at issue here. I think where the rubber hits the road, the place where they stumble, is by trying to broaden conduct from the replacement project to the entire Line 5. And I heard my friend Mr. Rinchenski, I believe this was in response to Justice Welch's questions about, or maybe it was Chief Justice Kavanaugh, no, it was Welch, about the question of, well, when's mere maintenance and when's something replacement? And he said, well, if you've got a new section of the pipeline that goes through a cornfield and it didn't do that before, then perhaps you can just analyze that and not the whole thing. That's 180 degrees the opposite of what they've told that PSC and every appellate court in this proceeding. Their position is, if you replace a portion of the pipeline, you reevaluate the whole thing. And that's why our friends who work for power companies and natural gas associations and things like that are so worried about this, because you turn a very limited inquiry, what's the repair and replacement remedy, and you turn it into a reexamination of the whole project. What happens when you do that? Companies aren't going to go and ask for the replacement. They're just going to continue to operate under a less environmentally safe alternative. Here, what incentive would Enbridge have to go to the PSC and ask for something like this? They could just keep operating.
But in a different scenario where the original project has already passed MEPA review, and then you're repairing a section or replacing it or something like that. So your baseline is different. Here, this pipeline was approved and installed and never went through MEPA review. So the idea that, it's a different baseline because of the particular project here. But this idea that nobody is going to come for that, well, 10 years ago, you got MEPA approval for the whole project. So now looking at a change to it is very different than we're looking at a change to it now on something that has never had MEPA review in the first place.
Yeah, there's two problems with that, Chief Justice Kavanaugh. First, that would suggest that somehow MEPA has a retroactive application to projects that were approved beforehand. That's an argument they've never made. But the larger problem is that that type of inquiry is preempted by the Federal Pipeline Safety Act as well as the Federal Common Law of Foreign Affairs as applied to this 1977 treaty. Even
For
if
a pipeline, right? But MPSC is looking at projects that are not just pipelines.
Oh,
right?
sure.
So when we're looking at the language of MEPA and what MPSC has to do in a particular case, what goes in this case does not necessarily go for good or for ill in every other MPSC review.
Yes, what should go in every case is the conduct at issue. As soon as you broaden that up to mean stuff that was already approved before, you're disincentivizing power companies, pipeline companies, anybody for asking for safety upgrades. Because as soon as they do that, it means a reevaluation of the whole project all over again, even if in a case like this one, the federal government has put its stamp of approval that this is safe and not impacting the environment in a harmful way. That's just opening up a Pandora's box that changes the meaning of MEPA and certainly changes the meaning of the PSC's Act 16 review. I've got about 2 minutes left, so just very briefly, I want to walk through why even the de novo standard is wrong, although it doesn't matter here. If you look at the entirety of MEPA, there are actually 3 ways that a case can be processed. So if the case gets filed, it can come in under 1701, and then under 1703, there would be a prima facie showing by the plaintiff that there's impairment. The defendant may rebut with submission of evidence. The burden of proof and weight of the evidence applicable in civil actions in the circuit courts all apply. Like, that's traditional original jurisdiction fact-finding. Bucket 2 is under 1704, and that's when the trial court, in its discretion or because it thinks it's required to, sends it to an administrative agency first to make a preliminary decision. And there, sub 3 of 1704 says that after that's over, the court retains its jurisdiction, may order that additional evidence be taken, and that the APA of 1969 does not apply. So in either one of those buckets, the court is acting as a fact finder. But when you get here to 1705, you've got judicial review, and we all know what that means. And it doesn't imply that this court or the Court of Appeals is taking evidence. The Michigan legislature knows how to say that you do de novo fact finding if it wants to do that. We cite some of those cases in our brief. And
Isn't de novo review different than de novo fact finding?
It
I
could
mean,
be.
we review factual records all the time, de novo. Appellate courts are more than equipped without adding witness boxes to appellate courtrooms, right?
Well, what they're asking for is all kinds of new evidence, and presumably if that comes in during a court proceeding, it wouldn't have to be at the agency level. Then there's going to be thousands of more pages. We're going to want to do cross-examinations in open court, and all those types of things. Here, it doesn't make any difference. They could put in all the evidence that they wanted, and it should be undisputed that having this put in the tunnel is the best alternative.
Can I ask you back to your original, like the different buckets, one through initiated through courts and the other through the agency proceedings. Why would the legislature want to have potentially different results depending upon whether somebody chooses the agency route or chooses litigation? Why wouldn't the legislature be looking to that you're not going, I mean, doesn't that sort of prompt gamesmanship of saying, look, I'm going to have a better route of getting through an appellate court if I go the agency route as opposed to going through the other route?
Well, the gamesmanship would be if the plaintiffs tried to circumvent the agency route so that they could get de novo fact-finding in a court, I think. But the reason why the legislature might do that is because the agency has the expertise. The PSC considers applications to make projects safer, whether it's pipelines, power plants, you name it, all the time. This is the business that they're in. That's why they've got experts on staff. They know how to go through thousands of pages of record. They can make findings like the one we have.
Did the agency here, had they done a MEPA analysis prior to this case?
I'm sorry, could you repeat that?
Had they ever done a MEPA analysis prior to this case?
Oh, sure.
Okay.
Yeah, absolutely.
In the same kinds of
In all the mill run cases, anytime that there's a project that has a possible impact on the environment, they're required by law to do a MEPA analysis.
And they had interveners in those cases, or this is the first one where that's occurred?
They've had interveners, they've taken evidence. I would say that this is probably, Mr. Sonneveld can correct me, the most massive record that the PSC has ever had in any proceeding in its history. Is that correct, Mr. Sonneveld? Correct. I mean, so this is one where anything related to the conduct at issue, the safety upgrade, the environmental improvement, was let into the record, and it was considered. And as I mentioned, there was that fact finding on page 305 of the opinion that this eliminates essentially any risk of a release in the Great Lakes, and that this protects tribal resources, it protects the environment, it protects the water. Like, this is the exact same thing that everybody should want. Environmentalists, tribes, protesters if they're outside, pipeline companies, everybody should want this pipeline in the tunnel. And so the only question for you is whether that's going to happen relatively soon or whether it's going to be put off another 5 or 6 years and that 0.001 risk of anchor strikes remains. So we would ask that you affirm the Court of Appeals in this case, or alternatively, just dismiss the application as improvidently granted. Again, whether you apply de novo or deference in your standard of review, it makes no difference to the outcome. It's better to have the pipeline in a tunnel.
Thank you.
Thank you.
I'm going to just jump in right ahead. I think, I mean, is the issue that is sort of in front of everything is the status quo is obviously, I think everyone agrees, not ideal. How do we handle that? How does that factor into our analysis? Obviously, Mr. Birch has made the argument about why it factors in. I would like your viewpoint.
So their position is the status quo is the dual pipelines, the existing segment can operate forever till the year 3000. That's just not true. We disagree with that. In terms of this construction being a solution, this project that may be constructed in 2032 if all goes right, which is a tall task for the highest water pressure tunnel ever built in the world, and putting a oil pipeline into a concrete tunnel, which has never been done anywhere in the world, is a tall ask. We don't think that's a solution. We seek to put on more evidence, as MEPA allows us to broaden the Commission's determinations in the aperture about what the status quo is, which we were not allowed to contest, but I submit to you it defies common sense to think it's the dual pipelines until the year 2100, which this project comes along with the 99-year lease.
Why
so I think
not,
it matters.
though? Why not, though? I don't understand. Short of, are you saying there's some other basis other than pending litigation about the easement or what have you? Is there some other basis for saying that it is not going to continue as it is outside of that litigation?
Yes, we seek to put on expert testimony. A piece of infrastructure have a design life. There's anecdotal evidence out in the world that this is already 20 years past its design life. We seek to put forth expert testimony of how long this can actually operate and go from there, compare how many additional decades of risk of oil spills will the tribal nations be subjected to based on the Commission's approval that will give this a 99-year lease versus with the existing segment and how long it can feasibly operate. If I may, Justice Thomas, I want to quickly address your question. There have never been interveners in an Act 16 case under MEPA, as Brother Counsel just represented. The Commission, actually until 2015, which is shown in Enbridge's Appendix 24, the Bugs case, took the position that MEPA did not apply to it at all, despite this court's decision in Vanderkloot. There's been one case in Act 9, a natural gas pipeline case since then, where they were not interveners. They were denied intervention, but appealed that going forward. So this is really the first time that it's happened. This agency has not been a faithful arbiter of MEPA over the decades, despite this court's decision in Vanderkloot. Really quickly, the idea that aging pipelines are not like your bones and can go on forever is just bizarre. There's a stack of PHMSA reports citing pipeline age or fatigue that is taller than me in terms of how long they can operate and how they lead to failure. And finally, this pipeline has spilled 36 times, about once every other year since it was built in 1953, over 1.1 million gallons. And before the Commission makes a decision that will subject these natural resources and tribal nations to those risks for additional decades longer than it otherwise would in absence of the Commission's approval, it should make an assessment of what those risks mean for Michigan's natural resources. Thankfully, MEPA requires that it does, and it gives interveners the ability to put on a case about it, and we respectfully request this court to send it back to the Commission for that to occur.
Counsel, what about the argument that there's just nothing the state can do? I know there's federal litigation. I know it's ongoing. I know there's been a lot of recent activity in those cases. What is your view on this sort of notion that it doesn't really matter, there's nothing we can do, it's out of our hands?
I think that's a fatalist view and is not aligned with either the state of the law, both in Michigan or the federal courts. The Attorney General has noted that is not the last word, and that case has been appealed. And it also discounts what the state can do in terms of alternatives. And it did matter here. When assessing an alternative southern pipeline route that goes along the southern tip of Lake Michigan, which would not pump oil through the Great Lakes for another century, the commission looked at things like, how close it goes to community water drinking sources, how many river and water crossings there are, how many miles of wetlands it will cross, and eventually determined that that wasn't prudent. But it did not, even though it would be feasible, but it did not look at those exact same things that come along with transporting oil from Sarnia, or from Superior, Wisconsin to Sarnia, Ontario, on Line 5. And to be clear, we're just looking at the Michigan sections of that and what risks are attenuated there. So I think there's a lot of things, whether it's alternatives or whether what the Attorney General has highlighted the state can continue to do to deal with the status quo. But in any event, the status quo is not this segment just can operate forever. It defies common sense and just the realities of engineering and physics to conclude that. And that's something we seek to put on evidence and testimony about. We shouldn't have to take Enbridge's word for it, and you shouldn't have to take our word for it. It should be something that's actually litigated and decided.
Thank you. The case will be submitted, and we will call the next case, which is For the Love of Water versus MPSC. And I think we'll have some changing of counsel. Okay, so calling this case For the Love of Water versus MPSC. This is another mini oral argument on the application. 20 minutes per side. Again, just repeat, there's a 2-minute fire-free zone, which we can start after if you want to introduce who's at table with you. And if you'd like to reserve any time for rebuttal, please do that and keep track and let us know how you're going to be sharing your time, if at all. Thank you.
Thank you, Chief Justice Kavanaugh, and may it please the court, Riaz Kanji on behalf of Flow Water Advocates. At council table with me, I have my colleagues Christopher Miller, Lucy Brown, Grace Judge, and Rebecca Milliken, all representing Flow. I will be presenting the entire argument. I would like to reserve 5 minutes for rebuttal time, and I will waive the free fire zone and welcome the court's questions at any point. I would like to start, given the way Mr. Birch is arguing the case and the court's questions, with this issue of the framing of the tunnel versus the dual pipelines, with the caveat that I do not think that is the proper legal framing of the case, but it's obviously an issue that's very present in the room. I think that narrative is the narrative that the choice here is between the tunnel and the dual pipelines, and that the analysis of the tunnel should therefore be a comparative analysis. It's a false framing, a false dichotomy for 4 reasons. First, no one is compelling Enbridge to continue the operation of the dual pipelines or of Line 5 through Michigan. The fact that Enbridge is holding the sword of Damocles over the state and engaging in environmentally hazardous activity is reason to apply the state's fundamental environmental laws more rather than less stringently. We are in the position we are today because in 1953, the public trust doctrine was not applied. You're absolutely right, Chief Justice Kavanaugh. MEPA did not exist at the time. Of course, the public trust doctrine did. Nobody paid heed to it in 1953 when the pipelines were laid on the bedlands of the Straits. And now we all have to deal with this incredibly messy issue. If history should not repeat itself, because if the tunnel is authorized without appropriate consideration for public trust concerns, we could very well be handing to the next generation another catastrophe of another environmental catastrophe. Secondly, and relatedly, the argument assumes that the dual pipelines will remain in operation indefinitely. There are at least two flaws with that problem. One, the court has alluded to. On the litigation front, Enbridge's argument rests entirely on Judge Yonkers' opinion, as if it is gospel, as Chief Justice Kavanaugh pointed out, and as I don't need to tell this court, appellate courts do exist for a reason. That decision is subject to appeal. That decision did not even reach the merits of the state's arguments. It was based entirely on preemption. And there is, and this relates to my third point, there's a tremendous irony in what Enbridge is arguing here, because it's saying that the state has no ability to regulate the safety of pipelines at all, to even enforce contract terms that Enbridge has agreed to. One of the ironies here is that under that very broad view of preemption, a very good portion of the MPSC's final order in this case, which purports to place conditions on Enbridge's construction and operation of the tunnel, would be preempted. You could redline the MPSC opinion if you take Judge Yonkers' opinion as gospel, and you would end up with a lot of the provisions in there being struck, which goes to the third point. The assumption is that the tunnel can be constructed and operated safely, free of risk, for a lot of reasons, and I can go into the details. A lot of this is covered in the amicus brief of the Great Lakes Business Network.
Counsel, can we jump right into the issues for this specific case, though? So with the first issue regarding whether or not MEPA incorporates public trust doctrine, if we agree with you on that point, do we need to get to the second issue at all?
No, Your Honor, but I think they are very related. So yes, you could decide this case based on MEPA and its incorporation of the public trust doctrine. The public trust doctrine, of course, very much informs MEPA, so I think the discussion ends up being tied together pretty intricately, in the sense that, and it really is, I think, fits together seamlessly. In Obrecht, this court held that there cannot be a dedication of public trust resources, including Great Lakes bottomlands, to private use without due findings being made, the public trust findings, that there will be no impairment of the public trust. The Obrecht court said that either the legislature or its designated agency needs to make those findings. The legislature, through the Great Lakes Submerged Lands Act, has designated EGLE as the agency to make those findings. And with that comes a corresponding duty on the part of other agencies to ensure that public trust resources are not dedicated to private use, absent those findings.
So I'm struggling with the authority for that. I don't know any other context, and maybe you can point me to that, in Michigan administrative law, where the agency would be allowed to effectively outsource their duty to a different agency to make that determination. Now, it may be that EGLE's obligation under the GLSLA, or whatever that is, GLSLA, they're fulfilling their obligation under that statute to they may to a different conclusion. But where is the authority that says, under the charge for the MPSC, to evaluate the public trust, and say we even agree with you that it has incorporated that common law doctrine into the statute, and therefore within the authority and obligation of MPSC to look at, that they then substitute the judgment of a different agency under a different statute to make that determination?
So a couple of responses, Your Honor. First, I really do not think it is outsourcing. I think if the commission were to recognize Eagle's primary role in making these determinations, the commission would in fact be honoring its public trust obligation. What MEPA requires is that impairments to public trust resources shall be determined. That's the language of 17052. It doesn't say, MEPA doesn't say which agency, it doesn't say that the agency issuing the permit has to make that determination. What it says is the determination needs to be made. And this court has been very clear that where you have multiple statutes that concern the same subject matter, you have to read them together as one. This court said that just last term in the 6 ARP case. You read them as one. And so MEPA, when it comes to Great Lakes bottomlands, needs to be read in conjunction with the Great Lakes Submerged Lands Act, which addresses the same subject matter. And the GLSLA makes very clear that it is Eagle that needs to make the public trust determination. So when you read the 2 statutes together, it's clear. And as I say, MEPA itself does not specify. The second part of the answer to your question is that this sort of arrangement, where you have multiple agencies addressing an issue, is not uncommon in Michigan administrative law. The legislature has in fact decreed that kind of arrangement across a broad variety of subject matters. I'll give at least one example, and more if the court's interested. A clear example is in the St. Clair Flats Act case, which concerns lands in Lake St. Clair that are upland of the bottomlands that are covered by the GLSLA. But for that next tranche of lands, many of those have been subject to long-term leases. And the St. Clair Flats Act case says that those leases can be converted into deeds. The DNR can issue permits, deed permits, but in order to do so, first, Eagle has to make various environmental determinations. It has to first determine that these are not actually bottomlands, but the next tranche of lands up. It has to make determinations with respect to the structures on those lands. Once Eagle provides the requisite certifications, then the DNR can issue the permit.
So in your example, that you have a statutory explicit direction saying DNR has to make this determination under the GLSLA. Aren't you, in this context though, under the MEPA, it's putting a lot of process and details behind the phrase shall determine public trust? To say that then you have to go and follow, and it's GLSLA and it's Eagle and all of that. I mean, I understand that the legislature can, reroute or what have you, direct to another agency, but wouldn't we then be relying on language that isn't present here?
I don't think so, Your Honor, for 2 reasons. First, again, the MEPA language does not prescribe the agency, and the Great Lakes Submerged Lands Act does, and they need to be read together. But secondly, I think it's critical to remember that we are operating, when we're talking about MEPA, under a statute that was meant to provide for the development of a common law of environmental quality. And it's very interesting when you go back and you look at the legislative history of MEPA, Professor Sachs's statements, when you look at the early decisions of this court in decisions like Ray and Vanderkloot, there was a very strong sense that the courts, the Michigan courts, were really going to be developing a robust common law geared towards environmental protection. I don't think it has necessarily worked out the way that was originally intended, but that doesn't mean it can't and that it shouldn't. And if your question here is, there are some interstices to fill in as you stitch the 2 statutes together, and there would be a pronouncement made by this court that would make clear how they work together as an integrated whole. With respect to MEPA, I do not think that is a bad thing or something that is contrary to the legislative intent or to the statute, because the very much intent behind the statute was that the courts would, and especially this court, would take these issues and fashion them into a integrated whole that makes sense in terms of environmental protection. And here's the...
So Counselor, I'm struggling with, so MEPA is a generally applicable statute, and so if there was a question of pollution that didn't touch on questions around bottomlands, and that went to an agency for determination, then what happens? It seems like that agency would be obliged to do the public trust analysis instead of Eagle because it wouldn't implicate the GLSLA. So I'm just trying to figure out, like, it's generally applicable, so it has to work in all instances.
That's correct, Your Honor. We agree, and we don't see an issue there. We're not arguing that Eagle always needs to make the public trust determination, because as you say, you can envision situations where there are public trust determinations that need to be made that don't implicate Great Lakes bottomlands. There's another big caveat to that, which is that the Inland Lakes and Streams Act also provides for a primacy role for Eagle. So, you know, the legislature has thought about a lot of public trust resources as being first and foremost in Eagle's purview. But we are not saying that it always has to be Eagle. But you read the statutes together to make the determination as to which agency is in that primary role.
So why isn't the answer to just send it back to the Public Service Commission, say you have to do a MEP analysis and it includes public trust? Like, why not just have them do it? Why are we sending it, having them defer to another agency when they're kind of responsible for this project, however you want to define it?
Two responses, Your Honor. First, again, on the letter of the law, because of the GLSLA, because it says very clearly, and this was the legislature acting pursuant to the mandate in Obrecht, it is Eagle that must make those determinations. And Eagle has promulgated Rule 1015 in order to fulfill that obligation. And Rule 1015 has a very different, and I think this is a critical feature of this case, a very different approach to these determinations than the approach that the commission has taken. And this goes back to the questions the court was asking in the first argument about alternatives. The commission did make something of an impairment determination. It found that there would be impairment to natural resources, but, and I think Chief Justice Kavanaugh's question went to this, it was a pretty cursory assessment, a pretty cursory determination. If you were intent on really understanding the public trust impacts here, as Eagle would be, you would have paid a lot of attention to evidence in the record, for example, and this is just for example, that the construction of this tunnel could wipe out whitefish and lake trout spawning grounds in the Straits of Mackinac forever, permanently. The testimony of Kevin Donner, the Little Traverse Bay fisheries manager, it goes exactly to that point. Fishery, I don't need to tell this court, but fisheries in the Straits of Mackinac, it's harder to get a more quintessential public trust resource than that. And you had the tribes.
So is it your view that that evidence is needed because then that informs the alternatives analysis?
It's our position, and this is exactly where I was going, and this is a critical point. No, because under the GLSLA and Eagle's approach in Rule 1015, once you find impairments, especially impairments of that magnitude to the public trust, that's the end of the analysis. Rule 1015 reads such that if you have those sorts of effects on the public trust, you'd never go to alternatives. And that's very consistent with the common law of the public trust and what the Obrecht court said, which is that you need, if you have a determination that there are impairments to the public trust, you cannot proceed. The commission's approach, by contrast, was to say, we read MEPA, and I think this is a misreading of 1705-2, and I can explain why, but we read MEPA to say, as soon as we find any impairment, we go straight to alternatives. And if we can't find a feasible and prudent alternative, it doesn't matter how stringent or how dramatic the public trust impairment is, we can still excuse it. And I think that's exactly the approach the commission took in this case. I think that approach is anathema to both the common law public trust doctrine and MEPA. It is certainly not in the service of environmental protection and quality, and that is I think fundamentally at bottom what this court needs to decide.
I'm struggling with sort of the circular logic of that, though. So let's say whether it's Eagle on its own or MPSC deferring to Eagle, making a determination under GLSLA that the impact is more than minimal you don't look at alternatives, the tunnel is a no-go, then what happens?
What happens in a practical sense?
If then the, the pipeline continues to exist, and as the law stands, unless and until it's overturned, Michigan doesn't have the ability to revoke the easement, at least under state law. So what happens?
So we're back to where we started
Yeah.
the argument, and I will answer that, and I'll try very hard to reserve a couple of minutes
Okay.
for rebuttal. We are not necessarily back to the dual pipelines operating indefinitely. We've talked about the litigation. Also, honestly, Your Honor, if the tunnel project comes off the table, that forces a sober-minded assessment, if not by Enbridge, by policymakers, including the Government of Canada, which has been a major driver of keeping the pipeline open, as to whether one really, in a sane world, wants the dual pipelines to continue indefinitely. That is a discussion that has not been had because there's been this prospect dangled out there that the tunnel is going to be built. And the final point on this, it's a false choice because as Mr. Birch himself said, Enbridge has projected 5 to 6 years for the construction of the tunnel. You can add a few years of that in reality, and then a few years more because of litigation challenges. You're talking about more than a decade of the dual pipelines continuing to operate even if the tunnel is built. If the dual pipelines are as dangerous as people understand them to be, a decade is too long, and the sober-minded assessment is what is needed. I will reserve the rest of my time. Thank you.
Thank you.
Daniel Sonneveld appearing on behalf of the Michigan Public Service Commission. I am sharing my time with Mr. Birch and will cede to him 15 minutes. This court has long held for years that my client has no authority to exercise common law. The Commission's powers are limited to the authority that has been given to it expressly by statute. The legislature has codified into MIPA the common law public trust doctrine as seen in Section 1705. By adhering to MIPA, the Commission believes it has met the requirements of the public trust doctrine and made appropriate findings in its nearly 350-page order. No further separate public trust analysis should be required on top of the MIPA analysis. Therefore, the Commission argues that the public trust was fully considered and resolved in this matter. Any claims otherwise should be viewed as incorrect, including those seeking to require the Commission to engage in any kind of redundant common law analysis for which it possesses no statutory authority. With respect to the court's citation of Glass, the Commission believes that is also completely distinguishable and therefore inapplicable. In Glass, there was a finding of an impairment of a protected right with respect to the ability to walk below the high water mark on Lake Huron. Here, no party has placed evidence on the record or demonstrated any impairment of a protected right concerning the replacement project. In fact, removal of the pipeline from the bottomlands could have the effect of increasing the opportunity to even exercise those rights, particularly with boating or fishing. The result here is that there is nothing further for the Commission to satisfy under the public trust doctrine, and the Commission believes it has already considered the environmental impact of the proposed project as pled by the parties and the environmental effects of the proposed alternatives. The Commission has fulfilled its obligations under statute. I now welcome any questions.
I'm struggling with your position not conflating what the statute says are two different inquiries, arguably, that evaluate the project's impact on air, water, or other natural resources, and the effect on the public trust. If you're saying when you evaluate, under MIPA, when MPSC evaluates the impact on air, water, other natural resources, they've satisfied the obligation to evaluate the impact on public trust. Do you think, maybe, what's your understanding or what's your definition of what public is?
Public trust is the codification of the Constitution's Article 4, Section 52, into the MIPA statute.
And so when MPSC or somebody else is looking at public trust, what is it that they are evaluating?
the impact on the public health, welfare, this mirrored language from Article 4.
Okay. And that, would you agree that that's different than looking at the impact on air, water, or other natural resources?
Yes, I would, but it all leads in the commission's minds to the alternatives analysis, which it performed.
Okay.
So I think Brother Counselor suggested that, and I want to see if this is the correct characterization of your reading of the statute, that once you find some impairment, then it goes straight to the analysis question. And so the scope or scale of the impairment isn't a relevant feature of the statute. So public trust could, even if you had skipped it, it doesn't matter because you've turned the light switch on to look at the alternatives analysis. Is that a correct characterization of your reading of the statute? And if so, why is that correct? Why doesn't the scope or scale of the impairment matter to amoeba analysis?
I think it's an oversimplification. I think the analysis that Brother Counsel is talking about that he wants performed, I think is actually done by the commission as part of its analysis, and it works its way through to the alternatives analysis. For example, I know there was also the questions about what was the impact of the various alternatives, and there was an argument that it was an apples to oranges comparison. When the feasible and prudent alternative extends beyond, say, the 4 miles, because the feasible and prudent alternative has to be based on existing infrastructure, like existing rail lines, I think you pull in the environmental impact, the public health, welfare impact when continuing the analysis through the entire application of 17052. I think it still gets done, and I think the commission, my client, did it.
But in the alternatives, so the scope comes in the alternatives analysis, not in the initial examination of the impairment in public trust.
I think it comes in initially, but it continues to be fleshed out through the alternatives analysis. If there's no further questions, I'd cede the remainder of time to Mr. Bursch.
Good morning, Your Honors. John Bursch on behalf of Enbridge. I think what we heard from Mr. Kanji this morning and also in Flo's reply brief really makes the second case an easy issue. I'm going to read from page 26 of the reply brief, but it mirrors his comments this morning. Eagle is currently reviewing a new modified permit application from Enbridge, and by all indications, the department is conducting a searching analysis of public trust considerations in connection with that review. So if this court wants to consider public trust considerations, you're going to have it when the appeal of that Eagle permit, grant or denial, comes before you. This is not the proceeding to do it because it's not within the scope of the PSC's jurisdiction. To the extent that you're worried that PSC is moving forward without that kind of finding, that's really a lack of a challenge by Flo and the other appellants to the legislative determinations that the public trust is not going to be injured, or at least it'll be benefited by this project. If you go back to the third agreement that Enbridge entered into with the government, this is section 4.2 sub D, it says that the state has acted in accordance with and in furtherance of the public's interest in the protection of waters, waterways, or bottomlands held in public trust by Michigan. And then you fast forward to 2018 PA 359. This is section 14 small a sub 5. Building on that third agreement, excuse me, it says that the tunnel upgrade is for the benefit of the people of this state and constitutes a public purpose. So if they wanted to challenge the legislative and executive branch determination that this advances the public trust, they should have challenged that legislation. There were challenges to that legislation. They failed in the Court of Appeals. There was no appeal taken timely to this court, and that's kind of off the table. But no one should be concerned about whether the public trust is being considered here, because Flo tells us in their brief that Eagle is taking care of it. And ironically, it's actually a belt and suspenders public trust analysis, because you have this separate Army Corps of Engineers proceeding taking place at the federal level for the last 6 years, and they just issued their environmental impact statement, the EIS, a month ago, and they took into account everything that they want the government to consider before making a decision like this. So, for example, on fishing, the EIS notes that there's going to be some impacts to the fishing, localized impacts as a result of the construction, but the impacts would not be expected to impair the recreational or commercial fishing industries after the project is over. So it's not that no one is considering these things, it's that they're being considered by the agencies that should be considering them, Eagle and the Army Corps.
Let's say, I mean, but the MEPA includes an obligation on MPSC to evaluate the public trust.
It does.
So while Eagle also has it, Office of Army Engineers also has it, MPSC has it under the statute. Let's say that's our position. What does that look like for the MPSC?
For the MPSC,
Under MEPA, performing a MEPA analysis, the statute requires them to consider the effect on public trust.
yes, and here they let in evidence as to how the public trust and the environment would be impacted by the tunnel construction, the safety and environmental upgrade. They didn't look at the whole project, and we've talked about that. But they did look at that, and they accepted that evidence. The tribe put in all kinds of evidence about the construction's impairment. He mentioned some of it, and the MPSC considered that. Now, I do think that Mr. Sonneveld is right. That's overshadowed somewhat by the reasonable and prudent alternatives analysis. And he's just wrong, Mr. Kanji is, when he says that under the common law, somehow that would look different, that once you've determined that there's a public trust impairment, that's the end of the inquiry. That would be nonsensical, because that means if you have an environmental improvement, like this project, that if it has any impact to the public trust whatsoever, then you can't do it. And you're left with the worst alternative of the status quo. And the common law public trust doctrine has never been implemented that way. And if you're thinking about traditional common law public trust interests, like swimming and fishing and boating and all those types of things, the long-term impact of having the pipeline in a tunnel advances all those things. It doesn't reduce them. So you do have to do an alternative analysis, whether it's under the statute or whether it's under the common law. And either way, the tunnel is a better solution than any of the alternatives that they've suggested. And I do want to go back to his point right at the very beginning that the pipeline won't operate indefinitely. Mr. Rachensky threw a couple barbs about this at the end of his argument as well. That's just not accurate. Yes, pipelines can wear out. If you have one that's along the ground with valves, with seams and other things like that, yes, they can age. They need to be replaced. That happens all the time. But when you're talking about a coated, seamless steel pipe in the water, it's not degrading. It doesn't have a lifetime. And if it did, then the ones who would be knocking on Enbridge's door saying, you need to replace this or else, would be PHMSA, the federal regulators who are the national experts in this and give more attention to this underwater pipeline than any pipeline in the United States. No one has ever suggested that. So that they can throw out all the common sense claims that they want. It's just not consistent with how pipelines actually in the United States. No one has ever suggested that. So that they can throw out all the common sense claims that they want. It's just not consistent with how pipelines actually operate. And that's also what's not at issue in this proceeding. The PSC...
Was that evidence presented to the MPSC? This competing evidence that you say it's never, it can live on for the rest of time because it's a seamless steel pipeline, and they're saying, no, it has some type of finite life. Was that presented to the MPSC in evaluating this idea of, is the continued operation of the pipeline, regardless of the lawsuits, an actual potential,
Yeah, Chief Justice Kavanaugh, in the thousands of pages of testimony, I can't recall whether that was put at issue, but in the PSC's determination, that was really irrelevant to their decision because they were asked to approve the tunnel or not.
Well, right, but I mean, I guess what you're saying is, like they're saying is, don't take my word for it, don't take your word for it, don't take their word for it. This is what the MPSC is supposed to do, is the reality or the potential that this operates for the rest of eternity actually a reality? And presumably the MPSC would make that determination, and it might agree with you. But they're the ones to make it, right? And that hasn't been fleshed out.
Well, except it's not their decision to make. That's the decision of the federal regulators, PHMSA, under the Pipeline Safety Act.
Well, but they're making it in trying to determine whether or not it's an alternative. that the status quo of this pipeline operating forever and ever is either the status quo or a potential alternative.
Well, except it's not an alternative, because if the permit is denied, Enbridge will keep operating the pipeline on the Straits lakebed indefinitely, contrary to what everyone wants. We want to eliminate that 0.0001 chance of an anchor strike. But the reality is that it will continue to operate. I mean, Mr. Kanji starts by saying no one is compelling Enbridge to do this. Well, in a sense, Enbridge is being compelled by the need of millions of people to have this fuel. Keep in mind that if this gets shut down, half the fuel to the Detroit airport is out of commission. If this is shut down, almost all residents of the Upper Peninsula, 2/3 of the residents in the Upper Lower Peninsula, will literally have no propane to heat their homes and to cook their food in Michigan winters, which is why when Governor Whitmer first purported to terminate the easement, which a federal court now says she can't do, she said, well, let's give it 6 months so we can figure out how to solve those problems. No one has actually solved those problems.
Counsel,
so there's a market requirement.
Counsel, I appreciate you bringing in kind of the real life perspective in terms of the real life implications. What would you say are the real life implications if there were a spill?
If there were a spill, it would be a potential disaster for the Great Lakes ecosystem. There's never been one. We hope that there's never one. That's why there's that 0.0001. And that's why it's so important that this court not use these delay tactics to delay for another 5 or 6 years the ability to start the tunnel construction. It's imperative that we do this as quickly as possible because, Justice Bernstein, those effects are potentially so dire. I mean, negligible when you're talking about 0.0001, but we can do better than that. We want to do better than that, and the state of Michigan agreed that we could do better than that.
Counsel, how do you respond to Mr. Kanji's point about federal preemption, and that if your view was correct, then obviously the MPSC would essentially have very little to do, it sounds like?
Yeah, that's absolutely not correct. So take the condition in the MPSC order that there shouldn't be other utility lines, like power lines, that should go in this tunnel. That was originally what Governor Snyder had requested. That was negotiated. Enbridge agreed to that. MPSC says, well, there's a risk of having another line in there with the pipeline. Well, that doesn't have anything to do with the operation of the pipeline itself. That's a collateral consequence. And PHMSA has long recognized that things like that can be regulated. When they're talking about tunnel construction and about what fluids, for example, are going to be released into the Great Lakes as part of building the tunnel, that doesn't have to do with the safety of the pipeline itself. Of course, that's something that can be enforced. What PHMSA is concerned about under the federal statute is the operation of the pipeline itself. And it is very good at regulating that pipeline, and that's why the pipeline continues to operate today without issue. But when you're talking about that collateral stuff, the PSC can step in, and we're absolutely going to do those things because that's what's in the best interests of the state and Michiganders. So I have 4 minutes left, but if there are no further questions, we're happy to rest on our briefs. Again, in conclusion, this is a binary choice. It's will the PSC's permitting decision be approved, or will this go back through 5 or 6 years of additional evidence gathering and decision-making and appeal process? And the Great Lakes ecosystem's safety and the interest of all Michiganders is that that be done as expeditiously as possible. We don't care, frankly, if you do that de novo or if you do it deferential. MEPA is easily satisfied. And same with the public trust. If you want to consider it, you can. Public trust interests clearly weigh in favor of the tunnel. And if you want to leave it to EGLE, the PSC order itself makes clear that the project cannot go forward until that permit and the Army Corps of Engineers permit are issued. Thank you.
Thank you. Mr. Kanji, you have 1 minute and 58 seconds.
I will try to talk fast, Your Honor. I won't spend very long on this because I have little time, but Mr. Birch does a lot of testifying from the podium, and I do want to make sure that certain things he said are not accepted as fact by this court. Nobody wants people in the Upper Peninsula to starve. Nobody wants the Detroit airport to shut down. Line 5 does not need to continue operating for either of those things to be true. All one needs to do is look at the PLG report from 2023, industry side reports cited in our briefs, which makes clear that there are plenty of other alternatives to Line 5. They are not alternatives that meet all of Enbridge's profit imperatives because they don't all involve the use of Enbridge infrastructure, but they do, Justice Bernstein, address the real life needs of real people. Secondly, this this business about pipelines, they can last forever. There's a well-known phenomenon in the pipeline industry. It's called the bathtub effect. You have the most problems with pipelines at the beginning because of improper construction, welds break, that kind of thing. Then you have a period where they generally do better, and then as they age, you come back up on the other side of the bathtub. We are in the state that had the largest inland oil spill in history with the spill into the Kalamazoo River from Enbridge's Line 6, which was an aged pipeline. Important to have facts and not just unbridled testimony. I will, on the law, I'll try to quickly address a few points. Mr. Birch agreed that EGLE is the right agency to make public trust determinations when it comes to Great Lakes bottomlands. And as he said, EGLE is well underway in that process. So under our view of the law here, we are not talking about indefinite delay before getting to a public trust determination, but what we are talking about is the proper agency with the requisite expertise making that determination. Chief Justice Kavanaugh, you asked about what is it like if MPSC has to do the public trust determination. The easy answer to that is it is not at all like what they've done thus far, and I gave the example of the absolute disregard, for example, about the impacts on the fisheries. Mr. Birch said, well, they took the testimony. It's not enough to take the testimony. You actually have to consider and delve into it. What the common law public trust doctrine requires and what MEPA and the GLSLA require are due findings, like an actual examination of the evidence of impacts on public trust uses. And this goes to Mr. Birch's other point about, well, the public trust was satisfied by the 2018 legislation or the third agreement. Those are simply assertions. And to say that those satisfy the public trust doctrine is to really make a mockery of the doctrine or to suggest how little regard my friends on the other side have for it. Obrecht is extremely clear. This court has been clear for a century that there needs to be examination, findings, and study. And I'll give you one example of...
Very quickly, because your time has expired.
And I'll give you one example, and I'll make one final point. The most important document when it comes to assessing the risks of tunnel construction in light of the geological conditions is a document called the Geotechnical Baseline Report. That is a report that makes a contractually binding assessment of risk and allocates risk. The MPSC never got that document from Enbridge. Enbridge never supplied it to the MPSC. EGLE, which is taking its obligations extremely seriously, has been asking and demanding for that document. This is all public record on the EGLE website. As of the beginning of this week, looking at EGLE's portal, Enbridge had not yet supplied that document. So the document that is key to assessing the risks involved here in the tunnel construction has never been studied by a state agency. And that's what we're talking about.
But that's different. I want to just quick follow up on that. So that's different than the public trust analysis, is it?
That is.
Okay.
I mean, that public trust analysis in the sense that if one's talking about the risks of tunnel construction, and for example, could the tunnel be overrun by waters given the world record pressures that this tunnel would be built at, and therefore have an effect on the water column? Could you end up having pollution of the water column because the tunnel collapses during construction? Yes, there is, but it also goes to this whole narrative about, well, the tunnel is absolutely safer than operating the dual pipelines. There needs to be study. That's what EGLE is studying. It's never been done. My final point, Mr. Birch, and I'll be very quick. Mr. Birch said that I was wrong, that it's never been stated that the public trust doctrine, that you don't work in alternatives, that you stop if you find impairments. Not only has this court said that repeatedly, and Obrecht is the sort of the hallmark case, but again, Rule 1015, which is EGLE's efforts to accomplish its obligations, to honor its obligations on the public trust, says that very clearly, that it will not allow a project to go forward if there are more than minimal adverse effects to the public trust or the natural resources. Thank you very much.
Thank you. The case will be submitted. I'll give a minute before I call the next case. And then there's the ones on the Enbridge side. And, you know, all the other employees. Laborers District Council. Anyone be left? Okay, I will call the next case. I think council can make their way up to the table at this point. And this is People of the State of Michigan versus Danielle Hess. This is a grant, 20 minutes of argument permitted per side. Ms. Lawton, you can reserve the time that you would like to for rebuttal. If you choose, we just ask that you keep track of that. And you will have 2 minutes of fire-free zone that you can waive if you choose.
I'm sorry, Your Honor. I'm having
Yeah.
I'm
It's a
having
little
a
loud.
little trouble hearing
Yeah.
you.
Let's wait for the doors to close. There we go. Okay. 20 minutes of our argument. You may reserve whatever time you'd like for rebuttal. We just ask to keep track of it. And you have 2 minutes of fire-free zone that you can waive if you would like. But go ahead and proceed with your argument when you're ready. And we'll get those doors closed so that everybody can hear each other. Okay. Go ahead.
Thank you. Good morning. May it please the court. Emma Lawton with the State Appellate Defender Office on behalf of Danielle Hess. With me at council table this morning is Imeme Umana. I intend to reserve 3 minutes for rebuttal. We ask this court today to overturn People versus Hess and People versus Lopez Hernandez, and to hold that the state legal use or possession of marijuana cannot be the basis for a probation violation in Michigan state courts. I welcome the court's questions at any time. 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 Welcome the court's questions at any time. Marijuana are legal in Michigan. Twice, Michigan voters have broken stride with the federal government's criminalization of marijuana. First, voters legalized medical marijuana, then voters legalized recreational marijuana. By ruling in People versus Hess that the federal prohibition of marijuana is a mandatory probation condition, the Court of Appeals requires our trial judges to ignore the clear directive of the voters and to continue penalizing lawful marijuana use in state court. The logic of this sweeping decision applies to recreational, no distinction between the two. It also raises other questions. Does a person violate their probation by lawfully working at a marijuana dispensary because in the eyes of the federal government they are distributing a Schedule I controlled substance? The answer is no, because in MRTMA, voters enacted broad protections protecting these types of penalties and lost privileges for MRTMA compliant behavior. That is true for all adults who are 20 here. That is true for all adults who are 20 here. That is true for all adults who are 20. It's a simple application of this rule. There has never been any allegation that she violated MRTMA. Yet the court revoked her HIDA and her probation because she lawfully used marijuana. And despite having successfully completed all of her probation terms, the court relied on Ms. Hess's lawful marijuana use to upwardly depart and impose jail and a misdemeanor retail fraud. So we know that the lawful marijuana use was penalized here. But the same protections apply to a person who lawfully uses marijuana after being convicted and sentenced to probation for an act that violated MRTMA. Their subsequent lawful use of marijuana cannot be a basis for a violation or for revoking
Counsel,
probation.
do we need to overrule Lopez Hernandez to help your client out? I know we originally had hoped to sort of have that on our docket, and that obviously, that case for a variety of reasons is no longer before us. So, I mean, sometimes we try to hear cases together when we can, and sometimes it doesn't work out. But I'm just wondering, I know in this case they relied on it somewhat, but do we need to even get to Lopez Hernandez for your case?
I think that depends on how the court wants to craft a rule. There is a rule that could be crafted that in cases where the person is not convicted of a MRTMA violation, that seems to me, as I said, that's a simple application, right? There are no MRTMA violations here. There are no questions about unlawful conduct in Ms. Hess's case. And so that is a rule the court could craft that leaves open the question under Lopez Hernandez. But I do think ultimately the plain text of the statute covers both of these circumstances. Because regardless of whether the person is on probation for a MRTMA violation or on probation for something totally unrelated to MRTMA, they are being punished for a probation violation. The violation itself, 771.4b says, the violation itself is being punished in a technical violation.
Counselor, there's the argument on the other side that actually the person is being punished for the underlying offense, and so in some instances that would be an underlying offense that is in fact prohibited by Section 4 of MRTMA. So why isn't the punishment for that underlying, in the Lopez Hernandez case, for that underlying Section 4 violating offense?
The reason for that is because there are, I would say, a couple of reasons. One is because the judge has already decided what the sentence for that will be. The sentence is probation. And there is nothing in the MRTMA statute that says the punishment for a MRTMA violation can be the prohibition of future lawful MRTMA conditions. And I think the example here starts to make sense when you think about things that are not use or possession of marijuana, when you think about working at a dispensary, owning a grow facility. Those are things that under Lopez Hernandez, also the judge could say you have to leave your job because that's a violation of federal law or because I don't think that's appropriate under MRTMA. I think the text of MRTMA is intended to prevent those types of situations. But I think also it's because the lawful use of marijuana as the violation is inextricably linked. The Court of Appeals says in Shaftsman, and this court stated in Hendrick, that the violation can be taken into account in sentencing the person once their probation has been revoked. And so if the probation is revoked for, let's say, an OWI with marijuana, as it was in Lopez Hernandez, then they are losing a privilege, probation, and they're being sentenced potentially more harshly because of the violation, which is the lawful use of marijuana. So although you are being sentenced for a violation of Section 4, your sentence is being enhanced or is being changed because of something that is protected under MRTMA.
Am I correct? A defendant is never required to serve a probation sentence, correct? There are no probation-only offenses in Michigan?
No, there are not.
Okay, so why should we not be looking at this of there's any number of any number of examples of lawful conduct that somebody may choose to forego in order to receive probation as opposed to a prison sentence, including, yes, legal alcohol use, including association with somebody, including the right to drive a vehicle, the right to be out at particular times, the right to consent to a Fourth Amendment search without probable cause. There's any number of conditions that somebody chooses to forego in order to avoid jail time. So why would agreeing to forego otherwise legal conduct under MRTMA be any different?
Because there has to be, it turns on whether or not what they are foregoing, that request to forego something, is in itself lawful. So for example, in the cases that are cited in my reply brief, Heil, Higgins, Pinckney, and similarly in this court's decision in People versus Virgil Smith, there are certain things that the law puts beyond punishment. So certain First Amendment burdens the decision in Virgil Smith to say, I will not run for office while I'm on probation, that this court looks at and says, even if you have negotiated that, as was done in Virgil Smith, even if this is part of your plea agreement, and you went into it knowing that this was part of the terms of the prosecutor offering you this plea agreement, because this is an unlawful condition, you cannot consent to it. In the case of MRTMA, it's unlawful because the voters have this explicit provision, which says there will not be any penalties imposed, there will not be any privileges revoked for the lawful use of marijuana.
So it's a matter of degree, right? Because you can, yes, perhaps not running for office over here, not, I don't know, think of any other sort of extreme or unconscionable condition that a court can't impose as a matter of probation. But there's plenty of other lawful conduct that can be. So is it a matter of degree? Is it a test of it has to be rationally related to the crime? It has to be rationally related to the objectives of rehabilitation, which, you know, as we know in our problem-solving courts, as effective as they are, you know, prohibiting the use of substances, even for non-substance related crimes, is an effective tool at rehabilitation and prohibiting recidivism. So is it a, you know, not just a black and white, MRTMA says you can smoke marijuana, therefore you could never preclude it. Is there sort of a test of how to evaluate when and under what circumstances it may be reasonably related, it may be unconscionable? How do we decide that?
I do think under the plain text of MRTMA, it is a black and white test. I think when you look at the text of MRTMA, what this statute is doing is putting the lawful personal possession and use of marijuana beyond the punishing power of the state. It's enacted by the voters, not the legislature, but it is saying this is behavior that cannot be punished. And so there is not a spectrum and there is not a rational relationship to limitation. It does mean a problem for treatment courts and for specialty courts. And that problem arose after People versus Thu, when the Court of Appeals interpreted similar language in the MMMA. The fix for that is what the legislature did for the MMMA, which is to say that specialty courts are an exception to that rule. They amended the MMMA, they added specialty courts to the exception so that they were no longer superseded by that provision. And that is the fix under it's very broad language in the text of the statute, but that is what the statute says. It says no penalty of any kind.
So if a trial judge says, defendant, I'm going to give you an option. You can do probation, and one of the conditions of probation will be you shall not use marijuana of any kind in any way, and probation will be a term of 2 years, or it's 6 months in the county jail. The defendant cannot accept that as an option. I'll agree to do this.
I don't think that the defendant can, because the judge in that scenario is conditioning the privilege on the defendant's agreement waiver of an unlawful condition. So the judge is saying, I am going to deny you the privilege.
But the judge can do the same thing with alcohol.
But there is no statute related to alcohol that has the text that MRTMA has. This is more protective.
You're focusing on the text, and I'm asking whether a defendant can agree.
Yes.
For a more beneficial sentence. Why can't this defendant agree? Oh, I'd much rather go without weed for 2 years than go to the county jail for 6 months.
Because the judge is conditioning this person's receipt of a privilege on because it's sort of like a backwards penalty, right? The judge is saying, if you don't agree to this, you will be penalized, you'll be sent to jail. I think a similar corollary would be if the judge said, you can agree to 3 years of probation, which is not authorized by the legislature, right? 2 years is the max for a misdemeanor. You can agree to 3 years of probation, or you can spend 6 months in the county jail. The judge does not have the lawful authority to impose 3 years of probation, and that's what this statute does. It makes it unlawful for the judge to impose this condition.
It's only a punishment if the defendant doesn't live up to the agreement. It's not a punishment if the defendant agrees and just doesn't smoke the weed, right? Or do the gummies or whatever it is.
But that conditions the person's probation on them. I mean, I think that would be the same thing, one could say the same thing about Pinckney, for example, where the judge said, don't engage in any defamatory conduct. If Mr. Pinckney had never written an op-ed criticizing the judge, he would never have had a probation violation. But he was aware of that condition going into probation, and ultimately, the Court of Appeals held that was an unlawful condition, he could not agree to it, and so he cannot be punished for later violating it.
Well, what about agreeing to, which I believe happens, what would otherwise be prohibited by the Fourth Amendment? That you agree to, you agree as a term of probation to have somebody, search your house.
There it's a balancing test, and that's because the Fourth Amendment has a balancing
Well, why
test.
is it that, for a constitutional provision, right? But for the statutory right under MRTMA, it's a black and white rule.
Because the statutory text of MRTMA creates a black and white rule.
Well, but the Constitution creates a black and white rule that you can't be subject to an unreasonable search and seizure.
Well, and that's where I say I was going to say it becomes a balancing test with relation to the probation conditions, because the case law on that actually says that a Fourth Amendment condition that is not tailored, that is simply any search or seizure, it's not tailored to the individual. Fourth Amendment condition that is not tailored, that is simply any search or seizure, it's not tailored to the individual or the offense, is unlawful under the Fourth Amendment.
So by analogy, why isn't a tailored condition surrounding MRTMA, why isn't that the analysis as opposed to a black and white rule?
Because then that brings us back to the text of MRTMA. So the Fourth Amendment, written 250 years ago, has been interpreted by the courts to have a balancing test. MRTMA, enacted by the voters in 2018, has a laundry list of things that are not allowed.
Okay.
And it has, yes, Your Honor.
Following up on this, I'll accept what you're saying. We'll take it out of the Fourth Amendment context and put it in the Second Amendment. Condition of probation, you shall give up your right to bear arms. Can the court do that?
Yes, because the Second Amendment permits that. Because when we're looking specifically at the text of MRTMA, MRTMA is doing things that the Second Amendment, with great respect to the Second Amendment, is not doing. MRTMA is telling us how to interpret the text in Section 2. It is telling us interpret it to the fullest extent possible with the purpose and intent elicited in this section. The Second Amendment purpose and intent elicited in this section. The Second Amendment, and MRTMA is also in Section 5 being written in the context where the people who are drafting this statute know how our courts interpret and tailor sentences. They know how we interpret penalties. They know how we interpret the Constitution. And that's why we have this lengthy paragraph saying no penalty of any kind.
Who knows how we do these things?
I'm sorry, Your Honor.
You said that they know how we interpret the Constitution. Who's they?
The drafters of this statute.
Well, it was a people-initiated legislation. So is it really whoever drafted it, or is it the people who voted on it?
I think it is both. The voters the drafters of the statute and the voters who are enacting it in the context of 250 years of interpreting our Constitution and interpreting our laws. And that is why this court has held that when we are evaluating voter-enacted legislation in particular, there has to be great deference to the voters.
I wrote that. I know. I'm very respectful of the exercise of direct democracy. But I don't think when the people voted for medical marijuana and recreational marijuana, they did so, in the context of the great history and tradition and heritage of jurisprudence, I'm supporting this. No, they voted for it because they believed that people ought to be able to use marijuana for a medical purpose, and then years later that they should be able to use it for a recreational purpose. I don't agree that they voted on it understanding how the Constitution has been interpreted, that we're giving extra power to this phrase, cannot be used as a penalty.
And respectfully, Your Honor, I have to disagree with that because they go out of their way to put in this purpose and to direct the court about how to interpret this statute, which is not something that we see in most statutes.
Counselor, looking at your specific case, is there any, I think we've posited that there would be this sort of agreement by the probationer. Is there anything in our record that supports that in this case, or that supports like the tailoring that's required under the straight-up probation statute? What is our record in this case with respect to that kind of agreement?
Specifically, the facts in this case. There is nothing in the record about the use of marijuana that contributed to this offense. There is nothing about this being a term of the plea agreement. The plea itself, the terms of the agreement that were put forth were that the offense would be reduced to a retail fraud third from a retail fraud second, and there would be no upfront jail. That is all that's negotiated at the plea, and the judge informs Ms. Hess, if I decide not to sentence you to probation, then you'll have an opportunity to revoke your plea. There's nothing about marijuana there. There's nothing about conditions. When they get to sentencing, the judge then lists out the probation conditions, and among them are the marijuana restrictions. So at that point, there's nothing that's been negotiated here, and there's no indication in this case that marijuana actually contributed to this offense or that there was any
What
more of a
if
violation.
it had been negotiated as part of the plea?
If it had been negotiated as part of the plea, then the remedy would be the remedy in People versus Virgil Smith, which is that the prosecutor would have the ability to revoke that plea agreement, and Ms. Hess would have the ability to go to trial on the retail fraud.
Counsel, taking that to its logical conclusion, are you suggesting that every time there's a plea agreement that provides for a term of probation, and then the catch-all language at the end, terms and conditions, that then includes, among other things, not possessing a firearm, not using controlled substances, the litany of other terms and conditions that are routinely included in probation? Are you suggesting that those pleas would also be invalid?
No, because if it just says terms and conditions of probation, the parties have not specifically negotiated a particular term. I think
But if it's silent, then those would be invalid. If it doesn't say terms and conditions at the bottom, but they do include the routine terms and conditions that are always included with probation, would those pleas also be invalid?
I think, well, no, because marijuana is not a routine, it should not be a routine condition. It is not a listed condition in the marijuana statute as it is listed out. And so that would not be a negotiated, unless it is a negotiated. So I'm saying if it was a negotiated term, if the parties say we want no marijuana to be a condition of this probation, you have to agree this. That's what the prosecutor says, and that's part of the agreement. The result would be the prosecutor has the ability to revoke probation. If it is just a plea agreement like Ms. Hess had, where that Ms. Hess had, where the agreement is we're going to reduce your charge and we are going to agree to probation, they haven't negotiated that special term of no marijuana. Subsection 11 says that courts are not supposed to be imposing mandatory standard conditions like no alcohol. Right? That is not a listed condition in the probation statute. That is supposed to be tailored to the offense and the offender and to rehabilitation and reconsidered over the course of probation. So the same thing for special conditions related to marijuana. That is, if it's not been negotiated by the parties and it's on the probation list, then the remedy is that probation condition is struck off and the person's plea remains intact.
Can I ask a question? If a condition in the statute that is permissible is that a probationer can agree to participate in inpatient or outpatient drug treatment. And if the condition of that treatment, which I would assume in most inpatient or outpatient treatment, is refraining from the use of marijuana, is that condition that's in the statute also impermissible? Or is it too attenuated?
That's something that we confronted after Thu with specialty courts, because, I mean, I was a defense attorney in specialty courts after Thu was passed, and we had individuals who were in treatment programs that required no marijuana, and they went and got a medical marijuana card. And while we were waiting for the legislature to fix that issue, they worked with their treatment programs to accommodate the fact that they had gotten a medical marijuana card. And we got through that until the legislature made that fix.
But legally, would it invalidate that portion of the probation statute that says that you participate in inpatient or outpatient treatment is an acceptable condition?
I think participate in inpatient or outpatient treatment remains a valid probation condition. Whether that person has violated their probation by using marijuana has to be decided at that violation hearing.
Okay. Okay. Thank you very much.
Thank you, Your Honors.
Your Honors, good morning. Tom Ginster from Montcalm County on behalf of the people. In granting the order to leave, for leave to appeal, the court simply asked us to juxtapose Michigan's Probation Act, both the mandatory and discretionary terms of probation, with the Michigan recreational marijuana statute, the MRTMA, and to ask if abstinence from marijuana is a lawful term of probation. So essentially, you must decide which law governs the sentencing decision. Conceptually, we believe that these two laws coexist in their separate spheres. The recreational marijuana law defines what law-abiding citizens can do. The Probation Act defines what a probationer must refrain from doing. So, of course, the District Circuit and Court of Appeals, they did find it to be a lawful term of probation. The circuit judge, Judge Krieger, in affirming the district court, noted that probationers are in a separate class of individuals. They don't enjoy the same liberty as law-abiding citizens. That's Griffin versus Wisconsin. The Supreme Court said the same thing in 1987. The Court of Appeals, for the first time, they kind of, unlike the dicta of Thu and Lopez Hernandez, for the first time, they found that the MRTMA, MRTMA, did not supersede the mandatory term of probation that the probationer shall not violate any criminal law of the United States. So the issue is whether there's anything in the MTRA that would necessitate that trial court judges disregard the plain language of MCL 771.31A, which requires probationers not to violate any criminal law of the United States. The dicta of Terbeek from this court, decided some 12 years ago, trains a great analysis of implied or silent repeal. It cites this court's earlier opinion in Wayne County Prosecutor versus the Department of Corrections that repeals by implication are not favored if there's any other reasonable construction. So the precise language is that it says, notwithstanding, this is the voter initiative, notwithstanding any other law, MRTMA compliant use of marijuana are not grounds for arrest, prosecution, or penalty of any manner, and not grounds to deny any other right or privileges. All laws inconsistent with this act do not apply that as conduct that is permitted by the act. So I would argue that this does not fall within the language of arrest, prosecution, or penalty, and because that speaks to the underlying offense. I would, if I'm going to have any integrity in my argument, I would say that it does, that the imposition of probation is a privilege. The words we should focus on, whether it applies to conduct that is permitted by the act. When they're saying conduct permitted by the act, I think they're referencing to what is allowed under state law. And Section 2 of the MRTA says the purpose of the act is to make recreational use of marijuana legal under state and local law. It doesn't say anything about federal law. Section 17 says nothing in this act purports to supersede any federal law, nor could it, even if it didn't have that provision in there. I think counsel is arguing, my sister counsel is arguing that upholding this mandatory term of probation, somehow we're forcing state judges in Michigan to enforce federal law. It talks, I think, this whole issue about the supremacy clause, it's a red herring. So respectfully, judges in Michigan, they don't have the authority to prosecute anyone. Nobody can step off the bench and you couldn't go out and issue somebody a traffic ticket, right? So probation violation is a regulation of conduct that relates back to the previously imposed criminal judgment. Ms. Hess is not being punished for smoking marijuana. She's facing punishment for the underlying offense. Revoking probation for a violation of federal law or for any reason is not a crime, as we cited in our brief, does not result. The revocation of probation, if proven by preponderance of the evidence, is merely implementation of the previously imposed sentence.
Counsel, if I could jump
Sure.
in and ask, let's say that we disagree with the Court of Appeals that opposing it as a condition of probation is mandatory under 1A. Can you address the second question? So say we disagree, it's not mandatory. So under what conditions, what would be your position is under what conditions it is permissible to impose that as a condition?
Sure. You know, rarely does the legislature come out and make your jobs a lot easier if they did, but rarely do they come out and say what their intent is. The probation statute says it's the intent of the legislature that the granting of probation is a matter of grace, requiring the agreement of the probationer to its granting and continuance. So we're saying that if this is a privilege, this privilege is inalienable. And as the Chief Justice asked before, even lawful terms of probation, or otherwise lawful conduct, can be a valid term of probation if rationally and reasonably related to the rehabilitation of the offender. So the court cited some examples, the Second Amendment. You could, I don't know what could be in the First Amendment, the right of association. You know, the courts routinely say you can't hang with felons. You got to stay away from schools. If you're in domestic violence, you can't go around your spouse or significant other for a while. What could be more sacrosanct than the Fourth Amendment protection against warrantless searches and seizures, but it's been the law of this state for 50 years plus, that a probationer can give up even a constitutional protection of the right of warrantless searches and seizures of the privacy of their home or vehicles or other things in exchange for conditional liberty.
So let's say I agree with you, and under subsection 3 that says we can, you know, the court can impose any lawful conditions of probation as the circumstances of the case require or warrant as in its proper judgment are proper. What do we need to see, like using the facts of this case, how has the lower court complied with subsection 3 that requiring the defendant to refrain from marijuana use was a condition that was proper, an exercise of proper judgment or consideration of the facts of the case? Do we have that here?
Sure, I'll be glad to address that. First, the lower court, as they noted, the Court of Appeals, that the fact that this is rationally related or reasonably related to Ms. Hess's rehabilitation was never contested. There is a strong and undeniable correlation, as Judge Krieger noted in the court below affirming the district court, between criminal activity and illicit substances. Your own court rule, when somebody that starts at the beginning of the process, when somebody comes in for an arraignment, it's a typical condition that you not use alcohol or any illicit substances, and that remains through the criminal process if they're convicted as a term of probation. So it is rationally related, and in this case, you know, if the court wanted to break the cycle of addiction here, Mrs. Hess came back to the court twice, so she had a really hard time abstaining, even while pregnant, from using marijuana. she agreed to it and then came back and then the court, the first violation said, okay, well, we want you to do 30 hours of community service, continue to pay your fines and costs, and then she violated it for a second time. So obviously it was an issue in her life where even after being ordered and agreeing to abstain, she was not able to. So I think it is a rationally related condition of probation. It's a typical term, and I don't think there
Well,
has
if
to
you say
be.
it's typical, and as you say, that it's used all the time, that doesn't seem to me that it's being tailored to the circumstances of the case or in a proper judgment, right? So, and maybe that was the case when, prior to MRTMA, or maybe even medical marijuana. But with the passage of those laws, is there a different analysis that's required where a judge has to evaluate what subsection 3 requires, and what would that be?
I think it was in a very practical term, Chief Justice, that if you were to require an individualized screening and assessment for substance abuse in every misdemeanor, given the volume of cases that come before these district courts, it would shut them down. Right now, of course, it's required typically in OWI prosecutions and driving while impaired, but I think that the courts have to be able to operate under the underlying premise that most of this crime, even the petty crime, is driven by substance abuse without that individualized assessment.
There's a presumption that any misdemeanor
There is
has
a
some
yes.
connection to marijuana use? I mean,
Yes,
that's kind of a
well, not
broad
specific to
presumption.
marijuana use, no, but to any mind-altering substances, including
Any
alcohol.
misdemeanor.
Yes.
So that wouldn't have to show up in a PSIR or something? Some evidence of that somewhere?
Unfortunately not, because I don't think that the courts really have the resource to do that for every other misdemeanor offense.
Counselor, do you think it matters to our inquiry whether or not the defendant committed an offense that violates Section 4 of MRTMA versus didn't commit, so the Lopez-Hernandez case versus this case, or do you think that's completely irrelevant?
No, that's a good question. What if the condition of probate, saying not to violate federal laws? Mr. Birch mentioned Detroit Metropolitan Airport. What if a state probationer had a CPL permit and decided it was a good idea to go to the commercial boarding area at Detroit Metropolitan Airport and was prosecuted under federal law? What if somebody shoots a wolf on Isle Royal, or if they commit mail fraud, or I can think of the other federal offenses, that's conduct that would otherwise be legal under state law? There shouldn't be any difference. And so the authority of the court here is not rooted in federal law. It's not rooted in the CSA. It's simply an instance of judicial power is applied to the operation of Michigan legislative will. The court's authority here doesn't derive from the CSA. It derives from the probation statute. And again, it doesn't supersede. There's no preemption. That's another straw man. And there's no federal supremacy analysis needed here. So to answer the court's question, it could be any offense, not just marijuana. So that's when they say, getting back to the specific language, when they're talking about the prohibitive language that's complained of, it said, we're only deciding under state law. This does not apply to conduct that is permitted by this act. They don't presume to change the federal CSA or the federal criminal laws of the state. There's like content neutrality. I just want to mention that your decision is against the backdrop of a rapidly changing drug policy terrain at the federal level. I know Congress has been squeamish about there's a great divide here, which is noted in the two, in Hernandez, Lopez, and in Thu, where they said there's one treatment for medicine, prescribed medicine, and then they both said in dicta, well, it would be okay for the court to regulate recreational marijuana without discussion. And in this case, the panel in the lower court decision also talks about that. And I think they were under the misapprehension of 21 USC that says if you have a script, then it's otherwise lawful. I think they're under the misapprehension that somehow medical marijuana right now is legal under federal law because it's not being funded and because there's no enthusiasm to enforce it. But as we speak, there has been White House has issued an executive order to order the DEA to reclassify this from a Schedule 1, which means no medicinal purposes and potential for abuse, to a Schedule 3. So where would that leave us? That would leave us in the position where medical marijuana prescribed by a doctor would continue to be a lawful or unlawful term of probation unless it's in the context of a drug specialty court or drug court.
Counselor, Sister Counsel makes a statutory argument that the statute bars revoking the privilege as a general principle, and then the statute has a number of exceptions that are considered. So, for example, it allows drug testing in workplaces. It allows a specific use in the context of child abuse and neglect. And having not made an exception for probation, we need to read that strictly. And so I'm hoping you can have an opportunity to respond to that.
Sure.
So why shouldn't we think they made exceptions for all of these other important public purposes, but not in this context?
Sure. Well, it was billed initially as regulating marijuana like alcohol, and it doesn't speak to probation. But again, probation is a privilege. It wasn't specified as an exception, and our position is, if it is a privilege, it's alienable, which means that it can be on a matter of contract. There's a lot of people that actually come into court. It's more frequent than you might expect. They come into court, they've been on probation before, and they actually choose jail instead of going on probation. They don't want to chase ping pong balls again. They don't want to submit to drug testing. They don't want to have their driving privileges limited. They don't want to be under supervision, so they choose jail. Ms. Hess, even though it wasn't an exception to that, we again reaffirm the principle this is an alienable right. It's a lawful term of probation. It's not unlawful. And there's nothing to suggest in this that the court need disregard the probation statute in fashioning a sentence.
Your opposing counsel cited us to Wayne County Prosecutor versus Smith, which was a plurality opinion. How do you deal with Smith? Is it just it's a plurality, not binding? Is it distinguishable from this case? What about Smith is different from this case as we try to resolve how we handle this case?
I think just if you look at Terbeek, which is not very helpful because that dealt with whether a municipality can freelance. It had to deal with state preemption. That has a very good discussion about whether the marijuana voter initiative, marijuana law, the MMMA, was in conflict with the probation statute. And they, again, reaffirmed that implied or silent repeal is disfavored. There's a presumption that this is valid, it's disfavored. I may not be familiar with the Smith case that you're referencing, but I think that there's a presumption that it is a valid term of probation. So again, just to finish my thought on this, I think when the Thu and Lopez Hernandez in dicta, I think they were misapprehension when they said that that recreational marijuana was a lawful term. I think there may have been a misapprehension of what the state of the federal law was. And that is rapidly changing. And so again, if marijuana at the federal level goes from a Schedule 1 to a Schedule 3, and you affirm this decision, then we're in the position where the courts may not lawfully prohibit somebody who has a script from, as a condition of probation, unless it's in the context of the drug courts or special courts, because there was, of course, a legislative response to THU, and I said in my brief it was by 2/3 of the legislature. Actually, under the Constitution, it requires 3/4. So that's where it would leave us. So again, under the Supremacy Clause argument, Congress never passed a law requiring that state court judges or the citizens of any states obey the criminal laws as a condition of state probation. So this isn't a supremacy argument. It's not federal preemption argument. It's simply whether the courts are free to disregard the clear mandate of Michigan's probation statute, which requires this as a mandatory term of probation, that they obey the criminal laws of the United States. Thank you.
Thank you. The case will be submitted. Okay, and calling our last case for today is People of the State of Michigan versus James Ellis Jr. This is a mini oral argument on the application, 20 minutes of argument per side. Ms. Zimbelman, I believe you are sharing 5 minutes of your time with the ACLU, is that correct? And then, Mr. Sanford, you are sharing 5 minutes of your time with Ms. Walton.
Actually, probably.
Okay, I will leave it to you to decide how to split your time. Obviously, you know that you have a couple minutes of fire free. Feel free to waive it, and also feel free to reserve what time you'd like for rebuttal.
Thank you, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of James Ellis. I'm joined at council table by co-counsel Chloe Bruick and ACLU amicus partner Marty Berger. In 1983, when Mr. Ellis was 19 years old, he committed an attempted CSC at a college party in Illinois. He didn't have to register because there was no registry. Fast forward 38 years to when Mr. Ellis attempted to steal a ribeye steak from a Walmart in Michigan. He pled to attempted unarmed robbery, and as a result of that, he has to register as a sex offender for the rest of his life under Michigan's recapture provision. This is unconstitutional, and this is ripe for review. In Kleinsmith, this court dismissed that appeal as moot because Mr. Kleinsmith could not be required to register, and there was no further relief that the appellate courts could offer him. The exact opposite is going on here. SORA is on Mr. Ellis's judgment of sentence. He can be required to register, and that requirement is impacting his choices right now. This is no more hypothetical than a probationer challenging the constitutionality of a probation condition before risking a violation of that very condition. This court can and must grant relief and vacate that part of Mr. Ellis's sentence. There's 3 ways this court can do that. First, the cleanest and most appropriate holding is that 2021 SORA violates the ex post facto clause. We know it's punishment under CARDAS, and it can't be applied retroactively to a sex offense that occurred in 1983. If this court believes that the attempted unarmed robbery is the triggering offense requiring registration, that is also improper under Lyman, where we know we cannot force registration based on a non-sexual offense. Third, the third path for this court, if this court believes that the underlying sex offense from 1983 distinguishes the attempted unarmed robbery from Lyman, then under the Lorenzen factors, it is cruel or unusual punishment to require a person required to register under the recapture provision of SORA. This is punishing the very people who have lived without committing another sex offense for decades. And I welcome the court's questions at any time. I want to talk a little bit about the ex post facto clause and which of these offenses actually triggers registration.
I have a factual question.
Yes.
So I know that your client here isn't on SORA, but if you look on SORA, there's a spot on there for offense. Mm-hmm. For someone who's subject to SORA based on a recapture provision, what offense is listed?
I would imagine, and I don't know for sure the answer to your question, Your Honor, but I would imagine it's the listed offense, because that is what triggers registration under SORA, a listed offense. The legislature's stated purpose in enacting SORA is to protect the public, ostensibly, from people recommitting a second or subsequent sex offense.
And are you aware of any Michigan State Police guidance or anything that would give us the answer to that question?
I am not, Your Honor. I am not. I would presume that Mr. Ellis was registered when he was in prison. When I filed this trial court motion raising this very issue, Mr. Ellis was incarcerated in a Michigan prison. We know that in Michigan, registration happens before a person goes to prison, so I would imagine he was on the registry. I didn't think to look at that time to see what it was. But I would imagine, since the goal of the legislature in enacting SORA is to alert the public to people who have committed a sex offense, they're not going to list an attempted unarmed robbery as what triggers registration. It's that 1983 attempted CSC. And that gets to whether this is an ex post facto question. Because as the court said, I was rereading the opinion in Tucker in preparation for this argument. And the court in Tucker said it attaches consequences to the non-sexual offense. But it is inextricably linked to that sex offense. And that's what makes this ex post facto punishment. If Mr. Ellis had committed an attempted CSC after the effective date of the statute, March 24th, 2021, he would no doubt be required to register. So his punishment stems directly from that sex offense. There's no world where the legislature would require registration based on trying to steal a steak from a Walmart or any non-sexual offense.
But Counselor, so Brother Counselor makes an argument this is similar to a recidivism provision or habitual offender provision. And certainly, I think there are some of those where the initial offenses are, what they are, and then the triggering offense is pretty minor, right? And so, but it triggers a tremendous punishment. And so, you're saying, well, this seems disproportionate to that, but that hasn't stopped us from analyzing those provisions as saying the punishment is tied to that last offense.
Yes, and that usually with recidivist statutes, it is repeat conduct of the same type. So you look at the typical recidivist statutes we have: domestic violence, OWI, second and subsequent drug enhancements. Certain repeat criminal sexual conduct offenses lead to a mandatory imposition of a sentence. That's repeated conduct of the same type here. We are in a different world when it comes to the recapture provision because it's not repeated conduct of the same type. Mr. Ellis has committed one sex offense in his life in 1983. So that was 43 years ago. He is not a recidivist when it comes to this particular statute.
But counsel, what about a habitual third or habitual fourth where it doesn't have to be the same type of offense?
I think what distinguishes that here, because I was thinking about the habitual offender enhancement and how that punishes repeat criminal conduct.
Just in general?
In general, right. It can be any offenses to lead to that habitual enhancement. And Mr. Ellis was a habitual offender here, and that was dismissed as part of his plea. But the difference here comes when looking at the purpose of SORA. Because in MCL 28.721A, the legislature says the goal here is preventing and protecting against the commission of future criminal sexual acts by convicted sex offenders. And that the registry is an effective means to monitor those persons who pose such a potential danger directly to the sex offense, not.
If I'm hearing you correctly, then that's something that would distinguish an opinion in this case that, say, agrees with you on that point from some future case where someone's challenging a HAB-4 enhancement on an ex post facto ground.
Sure, I think that would distinguish it because you have different purposes in a way that favors Mr. Ellis and not looking at this as a recidivist statute, which has typically survived ex post facto challenges. But even if this court doesn't think there's an ex post facto issue here, which there is, but if not, we can get into the cruel or unusual punishment analysis, and this fits cleanly in Lyman.
Counselor, before you get there, in sort of trying to figure out whether this is a punishment for the first or second offense. I'm looking at MCL 28.725, so a SOAR provision, subsection 15. And it talks about individuals in recapture cases where there's a term for the SORA. So your client has a lifetime.
Yes.
But if there's a term of years for the SORA, it states that the person can get what I'll say credit for time that they were not incarcerated. And it seems like that credit could go even before the second offense, right? So it could be after their sex offense, but before the triggering recapture provision.
Mm-hmm.
One, am I reading that right? And two, does that tell me whether this is an ex post facto challenge land or this is a cruel and unusual punishment challenge land?
I'm not familiar with that subsection of SORA, but I think it would lend to support that we're in ex post facto land. And that's because the extent of the punishment imposed here is all tied to that underlying sex offense. Mr. Ellis has to register as a Tier 3 registrant for the rest of his life based on the 1983 offense. It has nothing to do with maybe the legislature could have said, okay, if you have to register under the recapture provision, that's a Tier 1. We recognize that maybe you're not a recidivist sex offender, but that new offense means something. But all the punishment and the amount of punishment is tied to that underlying sex offense. He is Tier 3, lifetime registration until he dies. So even if he does get credit, he still has to register until he dies. I want to talk briefly about the cruel or unusual punishment factors. This is a straight application of Lyman, but I know that the Court of Appeals in this opinion below said, well, that 1983 offense makes him different than Mr. Lyman. And the Lorenzen factors show that just like this court did in Lyman, saying, okay, for this group of people who didn't commit a sex offense, they shouldn't have to register. That same holding could apply here. For people who have to register under the recapture provision, that is cruel or unusual punishment. And by the very definition of the recapture provision, every single person required to register under the recapture provision has made it at least 26 years without committing another sex offense. That's because the registry became effective on October 1st of 1995, and they are just now having to register based on the March 24th, 2021 SORA. So that is a disproportionate punishment for that offense, even considering the underlying sex offense. And it certainly cuts against rehabilitation. As we know from this court's opinions in Betts, Lyman, and Cardaz, the negative effects of SORA hinder rehabilitation. I'm going to save the rest of my time for rebuttal.
May it please the court, Marty Berger for the ACLU of Michigan, appearing as amicus. I'd like to thank the court for granting our motion to participate in oral argument today. The ACLU agrees with Mr. Ellis that the government finds itself in a constitutional catch-22. The recapture provision, regardless of which offense it punishes, is invalid either as an ex post facto law or as a form of cruel or unusual punishment. The threshold question is, which of those doctrines resolves this case? The ACLU submits that the recapture provision punishes decades-old sex crimes in violation of the state and federal ex post facto clauses. We know that's the case, and I welcome this court's questions at any time, because, to your Honor's question earlier, the registry does list the listed offense. The registry lists the individual under the code 999, other offense, and then proceeds to list the sex offense that subjected them to registration.
So someone is registered on SORA for a recapture offense. It would list the initial sex offense, and not in this matter, for example, the robbery.
It might list the other offense to designate that there is a robbery, but in addition to that, there would be the sex offense listed as well, the listed offense under SORA.
And is there any state police policy or anything that gives me the answer to that question?
Not that we are aware of. The basic reality that resolves this case is sex offender registration is punishment for sex crimes. The government asks you to ignore that basic reality on the theory that the recapture provision is some species of a recidivist statute, but that is not the case. Courts have held that a recidivist statute treats the prior conviction as something that makes a defendant more culpable for the recent offense. The recapture provision flips that and treats the more recent offense as nothing more than a trapdoor that subjects someone to the punishment for the prior conviction. For that reason, the recapture provision raises ex post facto concerns that traditional recidivist statutes do not implicate. First, the recapture provision channels people into a punitive scheme that by that scheme's own terms does not apply to the more recent conduct that's before the court at sentencing. SORA applies only to listed offenses. Attempted unarmed robbery is not a listed offense, and the recapture provision does not transform it into one. Second, the recapture provision attaches legal consequences based on the sex crime, not the more recent offense. The recapture provision triggers SORA, and under SORA, the tier level is determined by the sex crime, and that in terms determines how long somebody has to register and how frequently they'll report to law enforcement. Third, the recapture provision is so entwined with the underlying sex offense that the punishment it imposes will change whenever the legislature amends SORA to reclassify the sex offense within the tier system or adds a listed offense to SORA's definitions. As this court knows, that's hardly a theoretical risk, as the legislature has repeatedly amended SORA. And that's not true of a recapture provision. Under a recapture provision, a court considers the prior conviction only once, at the time of sentencing. There's no ongoing entwinement such that the punishment will change whenever the legislature changes the punishment associated with the prior conviction. Other indicators abound that the recapture provision punishes the prior offense. Consider the amount of punishment, which is the full extent of registration and reporting obligations associated with the sex crime. Consider also the type of punishment. The Michigan Penal Code does not provide for sex offender registration as punishment for attempted unarmed robbery. And SORA is likewise explicit that the penalties it creates do not attach to attempted unarmed robbery convictions. With those considerations in mind, it's just not natural to suggest, as would be true with the recapture provision, that as would be true with the recidivist statute, that the recapture provision enhances the penalty for attempted unarmed robbery, because under Michigan law, the punishment that it imposes cannot and does not apply to that offense. The government also argues that there can be no ex post facto violation here because Mr. Ellis committed attempted unarmed robbery only after the recapture provision was passed. I encourage the court to consult Landgraf versus USI Film Products, in which the US Supreme Court explained that laws can apply prospectively and still burden past conduct in ways that amount to retroactive lawmaking. Under Landgraf, all that matters to the ex post facto inquiry is whether a change in law attaches new consequences to past conduct. And that has to be right, because under any other rule, the government would have an easy way to accomplish indirectly what the ex post facto clauses prohibit it from doing directly.
So, Counselor, are you saying that even if we take the premise that he's being punished for the second offense, it's still under Landgraf the consequences of that prior offense? So that sort of binary doesn't necessarily answer the ex post facto question.
So I would frame it slightly differently. I would say that even if it's true that the recapture provision can't apply, but for conduct that postdates the recapture provision's application, it can still punish the first offense in ways that cause problems under the ex post facto clause. Consider, for example, the fact that taking the government's argument to its logical conclusion, the ex post facto clauses don't stop the legislature from passing a law that says that whenever a defendant is convicted of a new offense, a court has to comb through their criminal history, identify every prior conviction where the legislature has since increased the punishment, and apply sentencing enhancements to make up the difference. That's precisely the absurd result that the ex post facto clauses are meant to guard against, and that's largely because criminal defendants are among the unpopular groups whom the ex post facto clauses safeguards against arbitrary and vindictive punishment are supposed to protect most forcefully.
I just want you to be aware your 5 minutes is up. You're cutting Ms. Zimbelman's rebuttal time, and that's between the two of you. I just wanted you to be aware of it.
I appreciate that, Your Honor. In that case, we respectfully ask the court to strike down the recapture provision either as an ex post facto law or as a form of cruel or unusual punishment. Thank you.
Thank you.
Good afternoon. My name is Mark Sanford. I'm with the Berrien County Prosecutor's Office. Arguing alongside me today will be Danielle Walton from Genesee County. With regard to our lineup this afternoon, we've agreed to follow the time-honored tradition of age before beauty, hence I go first. With regard to the arguments, we've agreed to divide those up. And we've agreed to divide those up following yet another time-honored tradition. Those that have more abilities are stuck with more work. So I will only have one issue that I plan to address with the court today, and that would be the issue of ripeness. And then I would cede the remaining of my time and issues to Ms. Walton. Given my reduced workload, I promised Ms. Walton that I would try to keep my remarks to 5 minutes or less. And if I fail to do that, Eric Restuccia with the Attorney General's office is here to drag me away from the podium if necessary. So, ripeness. If the court were to take all of Michigan's ripeness law and boil it down into one test or one question that would be applicable to today's case, it would be this. If the court were to rule against the defendant on the substantive issues, the day after that ruling, would the defendant wake up and have to do something different? In other words, the day following this court's ruling, will the defendant be put to a choice to either refrain from doing an act or engaging in that act and facing likely prosecution? And in this case, it boils down even further to this. The day after the court's ruling, will the defendant be faced with the choice of either staying in Indiana rather than moving to Michigan, or moving to Michigan and face possible consequences?
Counsel, how do you respond to the argument that's been made in the briefs that this is defendant's really only shot at challenging the provision here?
Well, that's simply
because
not...
otherwise res judicata binds the courts later. So
Sure.
how is it not ripe if
Sure.
that's the case?
If the defendant were ever to show an intent to move into Michigan, he has several options. And again, that has to be a genuine intent to move into Michigan. He would have the option of filing a motion for declaratory judgment under MCR 2.605, which is what this court, in fact, in Spencer, a 2013 case, recommended in situations like this. Also, the defendant could file a motion under MCR 6.429, a motion to correct an invalid sentence. And if he's past that deadline, that court rule rolls him out into MCR 6.500.
So Counselor, he raised on direct appeal a challenge to SORA as an invalid sentence because he didn't live in Michigan. And I assume that your office opposed that challenge. And so he has to first move to Michigan, or what does he have to show? Just more intent? If he lives in Tennessee, maybe it's not ripe, but since he lives 5 miles from the border, it is ripe. Like, how do we make those gradations?
Sure. And I don't think those distinctions of which state is closer really dictates that answer. The test that this court adopted just a year and a half ago in People versus Warner essentially adopted a case from the 1990s, DSS versus Emmanuel Baptist Preschool. And a concurrence in that case, authored by then Justice Kavanaugh, laid out a 3-part test for us, right? One of the prongs doesn't matter here. There is no need for further factual argument. But the second and third prongs talk about injuries, the certainty of the injury and the potential hardship of that injury. Now, both of those beg the question or are informed by the question of the defendant's intent, which is, I think, where your question is going. The defendant has to intend to move into Michigan. And I think the facts of our case clearly show that he does not have that intent.
It's live temporarily, work, or go to school in the state, right?
Correct. And we have seen zero facts, and I listened today, they didn't mention anything of defendant's intent to do any of those things. It's not like he's got a towing truck, or a tow truck with all his furniture in it, ready to move into Michigan on the day following this case, because he has no intention of moving into Michigan. And if he has no intention of moving into Michigan, then there is no injury. And if he's got no injury, any harm, potential harm, is purely speculative, and therefore it's not right for this court's review. And I would use this simple analogy because it seems to work for me, right? My wife has an allergy to strawberries. She hasn't eaten a strawberry since she was a kid. And while she intends to never eat a strawberry again, it's not because of her allergy. It's because she doesn't like the taste. She doesn't like the texture of strawberries. So she is never intending to eat a strawberry again, but not because of her allergy. It's because of the taste. Similarly, this defendant has never intended to move into Michigan, not because of SORA or potential prosecution, but because his home has been and will be in the state of Indiana. And unless we have that intent to move into Michigan, again, there is no injury, there is nothing but speculative harm, and the case is not ripe.
I will note that you are now 7 minutes into
I'm
your
at 7
argument.
minutes? Yikes, Eric.
It goes fast, doesn't it?
Yeah. Thank you.
Yes.
Madam Chief Justice, fellow justices, may it please the court, Assistant Prosecutor Danielle Walton from the Genesee County Prosecutor's Office, representing the Prosecuting Attorneys Association of Michigan. So for reasons stated by the people, this case is not ripe. But even if someday in the future this defendant would decide, I'm going to come to Michigan on a temporary short-term basis, at best, he would have to register his temporary residence. Defendant hasn't cited any case across the United States that would have found that this short-term registration would amount to any type of punishment. It's not a significant affirmative disability, it's not significant shaming, and it's not particularly retributive as to him if he goes home and he's off the registry. But even if defendant could show by the clearest proof that this temporary registration status would amount to punishment, he cannot show that there could possibly be an ex post facto violation or that this punishment would be grossly disproportionate punishment. So in this case, as for the ex post facto clause, defendant hasn't shown that there could possibly be ex post facto violation because he committed the crime that triggered the registration 10 years after the 2011 SORA was passed. So he's placed on ample notice. So neither Michigan nor the United States Supreme Court has adopted this but-for or proximate cause test advocated both by SATO and the ACLU, nor have they cited any case which has adopted this but-for or proximate cause. In fact, to adopt that test would mean that Michigan would have to part ways from the United States Supreme Court. It would have to disregard the fact that our two clauses are almost identical, disregard our language in the Constitutional Convention that shows that we don't intend to divert, and this court would have to overrule cases such as In re Miller, People versus Palm, People versus Miller, and People versus Reichenbach. Instead, the question is, as Carmel and Weaver stated in the United States Supreme Court, whether the act which triggered the consequences was completed after the passage of the statute. This crime was not completed until he committed the felony in 2021. If he had never committed the felony, he wouldn't have had to register, so there could not be an ex post facto violation. I would just ask that this court, did you have a question? I'd ask this court that adopt what Johnson versus Madigan, the Seventh Circuit, they have considered almost the identical case to this case. In Johnson versus Madigan, Johnson committed a sex crime back in the 80s. He was off the registry. Illinois passed a recapture provision. Then in 2013, he committed a theft offense. Could be this case. And what did Johnson versus Madigan say when Johnson challenged the registry as ex post facto? But Mr. Johnson isn't here because of his 1983 case, his sentence. That sentence, including the requirement of registration, expired long ago. He became a sexual predator as a collateral consequence of his 2013 sentence, not through enforcement or modification of the 1983 sentence. His prior criminal record simply increased the consequences of his 2013 conviction, a stiffened penalty for the last crime. So why is that so? And I think we look at a case like People versus Bingham. The Illinois case talked about what is the purpose of this recapture provision. Illinois passed a recapture provision like Michigan, and Bingham said the legislature could have reasonably determined that where a defendant commits a sex offense in the past for which he was not required to recidivate and has shown a recent general tendency to recidivate by committing a new felony offense. Since the amendment of the act in 2011, he poses a serious threat. So is it the sex offense that tells the legislature he's a threat now? No, it's the fact that he lacked impulse control and committed this new violent felony.
Counselor, can you let me know if the ACL lawyer is representing that if someone is registered for a recapture offense on SORA, what offense is listed as a factual matter on the registry? What offense is listed there on the website?
My understanding, it is the listed offense. And it's not specifically stated, but I would look at 28722I and 2872331E. That kind of lends to the conclusion that it's the listed offense that would be on the registry, which makes sense. But that being said, so the question is, first of all, I just want to look a little bit about what the consequences would be if this court ruled on ex post facto grounds. Well, number one, as amicus submits, it would really do violence to Michigan's recidivism cases, and that would really have impact for all types of cases such as Heidi's Law, habitual offender, felon in possession, and all those that are listed in the brief. But secondly, if this court would rule broadly, that would mean 30,000 offenders would come off. And the ACLU acknowledges this court could rule narrowly, but we would suggest if this court is considering the ex post facto argument, which amicus suggests this court could not, there are viable arguments on severance, which the state police would like to be heard on. But here, this case is not an ex post facto case. This is a cruel and unusual punishment case, and I'd really like to respond to the argument why. What about the fact that this defendant committed a new offense? What makes him a risk? So that's the critical question for the grossly disproportionate penalty function. First of all, we know he committed one of the most serious sex offenses in Michigan, but what is it about defendant committing this violent offense? So the ACLU filed 140 pages of statistics, really relying on Carl Hansen. So what does Carl Hansen say? Well, look at the static 99R, where there are criticisms about that tool, but what does he say are risks for reoffense? The fact that a defendant commits four or more offenses. The fact that defendant commits a violent offense. Well, what is it about a defendant committing a violent offense, like defendant did in this case? The court made a factual finding that the defendant punched the loss prevention officer in the face. What is it that shows that he's going to be at risk of committing a sexual offense in the future? Well, what does the static 99 say? Yeah, there's this risk, there's this link.
Counselor, was there a static 99 done at his sentencing on the armed robbery?
No, no. It wouldn't have been done. It wouldn't have been done. So, but if we look at some of the risk factors that are mentioned in the static 99, there's this link between violence and sexual recidivism.
Okay,
and what
but
did
there's
Carl...
nothing specific to this individual that's in front of us today.
No, no. But if we look at this particular individual, what shows that he's going to be a risk? Well, as Carl Hansen stated in 2004 in his study that's mentioned by the Department of Justice, what are the class of offenders are some of the highest rate of reoffense? Violent sex offenders, 24% after 15 years. The Department of Justice said 39% after 25 years. And what did Carl Hansen state in the 140 pages of statistics? Which are the victims that are the least likely to report? Victims of violent sex offenders, 10% reported. So this is a high rate of recidivism, low rate of report, 6 to 14% chance of conviction. And let's look at this defendant. Well, he
Counselor,
committed.
before we get there, can I just back
Right.
up and sort of, I'm still on the figuring out which box we're in questions. So I asked Sister Counselor about a provision of the SORA, MCR 28.725 subsection 15. And I believe, and tell me if I'm wrong, that that is addressed to recapture provision cases.
Yes.
And allows, I'm using the word credit, it doesn't use that language in the statute, but it looks like credit, you can get credit for non-criminal time prior to the second offense. And if that is in fact what the statute does that suggest that we should think about this as an ex post facto because you're doing your time for SORA prior to having committed the second offense? Or should I read that a different way?
Yeah, and I would say no, and the answer is that he wouldn't be on the registry unless he committed this felony. So let's assume for the sake of argument that we had full retroactivity like SORNA. And all of a sudden, 2011 was passed and he's on the registry. Clearly ex post facto. But here, the way that the statute is crafted, there can't be an ex post facto problem because he won't be on the registry until after the 2011 SORA was passed with these consequences. He commits the new offense. That would be inconsistent with Weaver, inconsistent with the United States Supreme Court in Carmel. If it's completed after the date the statute was passed, then it is not an ex post facto case. Really, this case should all be about punishment under the grossly disproportionate penalty. That is the box that this court
But in
should.
theory, under this provision, if someone has a 10-year offense and they commit a sex crime in 1980s, they could be done with the SORA requirement prior to the passage of SORA. So does
Yes.
that pose a problem?
No, he just wouldn't have those consequences. It would only be triggered. It will never be triggered unless he commits the new felony, and that is the distinguishing difference. That's what ex post facto is. He's received notice 10 years ahead. He might have to serve this consequence, or he might not have to, but in 2021, these were the consequences he was placed on notice of. If you commit a felony, and maybe you had a tier 1, then you might not have to serve at all, but that's your consequences, which comes into play only when he commits the felony. It'd be different if we had a different SORA, like SORNA. That would be a problem, but not Michigan's recapture provision. So I want to just a little bit talk about, I know we were talking about why is this a specific offender a risk, and why should the legislature reasonably presume that he poses a serious menace to the citizens of Michigan. Here, defendant committed a violent sex offense, a violent attempted rape at knife point, a robbery, and a battery. Then throughout the course of his life, he committed the equivalent of 9 violent felonies. He committed violations of a protective order, the invasion of privacy, and then he commits this violent attempted unarmed robbery. He punches the loss prevention officer in the face. So, and in the pre-sentence report, it indicates that he committed another assault of another loss prevention officer. So reasonably in the future, if defendant were involved with a sexual partner that somehow thwarted his desires, that argued with him, what is the likelihood, looking at this past criminal history, which includes 24 felonies and 14 misdemeanors, what is it likely that he's going to respond in violence? Looking at this particular history, one would say that the citizens of the state of Michigan, if you ever would move here, which is unlikely, are at risk. 1 second. If this court has any further questions, we'd ask that this court affirm the lower court. Thank you, Your Honors.
Thank you. You have 2 minutes and 54 seconds for rebuttal.
I want to talk primarily about ripeness, but I can't let the comments about my client go unaddressed. What does his actual record show? That he committed an attempted sex offense when he was 19 years old at a college party. He has since went 43 years without committing another sex offense. He, without the albatross of SORA, has met the purpose of the legislature in enacting SORA. I want to talk briefly about ripeness. There's no requirement that Mr. Ellis has to show a genuine intent to move to the state of Michigan in order to challenge a part of his sentence. Again, it is on his sentence. He is facing injury now because that part of his sentence is impacting his life choices. He could have come to watch this argument today. It's about his constitutional rights. He could have come here. He's not under state supervision, but he maybe didn't want to risk it because there is a real risk, because not only would he be subject to registration if he moved here or worked here or went to school here, he would be subject to registration if he temporarily resides here. That term is not defined in SORA. We have no way to know what that means. So that risk of this burdensome registration statute is impacting his life choices. What if he came to watch argument today and he got in a car accident and he had an extended stay in a hospital? Would that be temporarily residing in Michigan? Would that trigger his registration responsibilities? And then thereby, that would make him have to register in Indiana, because Indiana's registry says if you have to register somewhere else, you now have to register in Michigan.
Counsel, could you respond to the argument that nowhere else in the nation is sort of punishment interpreted so broadly for purposes of ripeness? I think Sister Counsel made a point about that.
Well, I don't agree with that, and I would point out that there are only 2 other states who even have a recapture provision. So if we want to talk about what punishment looks like in this particular context, that does get to one of the Lorenzen factors as well. But this court in Warner, and opposing counsel brought up Warner, this court had a very long discussion about ripeness and mootness. And one thing that this court did acknowledge is that there can be a balancing test to grant anticipatory relief. So even if this court thinks for some reason that Mr. Ellis is not experiencing injury now and challenging it on his direct appeal, this court talked in Warner about how you can balance the need for further factual development, which we don't need here, including combined with any uncertainty as to whether the defendant will actually suffer, with the potential hardship of denying anticipatory relief. And so this court found it wasn't moot and it was ripe for Mr. Warner, and we ask that it do the same for Mr. Ellis. Thank you.
Thank you very much. The case will be submitted, and that concludes our call for today, so the court stands adjourned. Thank you.